I'm stuck with that name.
All right. No worries. I'll go back to the drawing board. It was good to see you, though. Stay safe.
Okay, you too.
All right,
See
take
ya.
care.
All right.
Good morning, Tammy. This is Attorney Jordan.
Good morning. What do you have this morning?
So I had a case for Patrick Smith up before Judge Jones for PCC this morning, but he
Okay,
also
anything-
has an. I'm sorry.
Go ahead.
He has another case that's set for exam before Judge Archer on October 20th. So they told us
Okay.
to log in here to get a to handle the PCC and get another court date.
So do you want another probable cause day or do you have discovery?
I do not have discovery.
Okay. So I just let our prosecutor know about this, so she wasn't aware of it being transferred over. So do you want another probable cause so she can get you to discovery?
Yes.
Does August 11th work for you?
It should. August 11th is good.
Okay. Judge, Mr. Bloomers needs to go into a breakout room with the complaining witness, because I think she's getting ready to sign off. She just sent me an email. Ms. Robinson,
Yes, ma'am.
the Judge Archer is going to put you in a breakout room with the prosecutor, okay?
Thank you.
Don't sign off just yet. Wait until you talk to the prosecutor.
Okay, thank you.
All right.
Tammy,
Mr.
do I have to
Bloomers,
stay on?
you do not. We're all set, Ms. Jordan.
Okay, you can log off, Mr. Patrick Smith. I'll call you.
All right, thank you. All right.
Yes. Something's going on. Yeah, something's going on. Let me see real quick. Ms. Coleman, do you need to go into a breakout room with Mr. Randall?
313-418.
I'm still, I haven't seen the video yet. I'll look at it and then can explain to him what's going on today. So yes.
So you want a breakout room? Yes or no?
Yes, please. Yes,
good
I'm
morning.
sorry.
Support the Solomon. Okay, so who is the breakout? He's in
Good
custody.
morning.
Wayne County Division 1, what is, do I have a Mr. Randall?
Oh, yeah, I see that.
We had two of them, I thought, Judge,
I
so
think
I'm not
it
sure.
says Randall.
Oh, okay, okay. And then I also had, I don't know who this
Jalen
is.
Randall checking in.
They're gonna put us in a breakout room. Just a minute, Mr. Randall.
Oh, well, you should have already received the invitation. Let me know if I should send it again, but it's there.
And then Division 1, what's your name again, sir?
I need it again.
Jalen Randall.
I know that.
I think it's still sitting there, ready for you to accept, but I'll do it again.
I can't see it. I've pushed the whole screen and nothing to say breakout room has come up.
Okay. Mr. Bloomers, were you done or did you need to go back in there?
We were still talking. It's I got a message that it was just going to end on its own for some reason.
Yeah, I think it glitched. I'm gonna put you back in there.
I'm back, Tammy.
Okay, just give me a moment, Mr. Glandon. We're trying to get our breakout room situated. Mr. Simon. Mr. On the other jail, I think the attorney is signed in, just the judge.
Okay.
And I can't call this DB case because Mr. Everything I have that I need to call is a DB. And Mr. Bowers is in the breakout room. Let's see. Hey, Mr. Simon, this is Tammy from Judge Archer's courtroom. Okay, because we have your guys up on video from the jail. Okay, all right, fine. I'll start calling these cases as soon as we get the DB prosecutor back. Everything I have to call is a DB matter.
Tammy, on the Moss Matthews matter, did they say they were going to come on the 27th to track it along the view code amendment? Or did we already?
Yes, they're just gonna zoom in on the 22nd. But I didn't know if I needed to leave him on the 22nd as well, because we kicked him out to October 13th. So I don't know.
He doesn't need to be there.
Yeah, so I changed it to just a court date instead of an exam date. And
Okay.
then
Oh,
I'm supposed to zoom
Just
in.
with Moss Matthews?
Yeah, he's
Okay.
supposed to zoom in. Judge Archer's courtroom, Tammy. Okay. And what's the last name again? Okay, at 11:30, okay. Good. Easier said than done. I mean, I guess he can zoom in. Can he get someone to stand in? I mean, first off, he needs to send an email to the prosecutors and let them know what's going on. And then we can call it on Friday. If he wants to have someone stand in for him and zoom in on Friday after he speaks with the prosecutors. Pardon me? Yes, because it's scheduled for Monday, so if he wanted an adjournment, we need an adjournment before then. Okay, but he needs to let the prosecutors know what's going on too. Okay? Okay, all right, no problem. All right, bye. Good morning, Ms. Michaels.
Good morning, how are you?
Good. You're here on Ashley Johnson?
Correct.
Okay, and what did you want to do this morning?
We don't have discovery yet, so even though I requested it, so we'll have to ask for another PCC.
Okay, is that, that's Mr. Slusky's case, isn't it? Ashley Johnson?
Yes, ma'am.
Okay. Do you want to hold on here and talk to him? I'm not sure if he's signed on yet, or
Oh,
do
here
you
he
just
is.
want to?
I'm here,
Hi,
Tammy.
Mr. Slusky, I'm on Ashley Johnson. I requested discovery through evidence.com, have not received it yet.
Okay, let me check. If it's been uploaded, I can get it to you today.
Great.
It'll take me a little bit longer to get that uploaded and send it out to you. I found most of the time it is uploaded, but it's kind of close to 50-50. So I'm just checking on that now, and I will let you know immediately if I can send it to you immediately.
Okay.
Does August 11th work for you for another probable cause date, or do you want to just set it for an exam? We're in December.
Let's just set it for exam.
Okay, so that's gonna be December 17th at 10:30.
Okay.
All right, 10:30 works for me. And Ms. Michaels, I unfortunately was not able to find it online. So I'll have to track down the file and make sure it gets uploaded. There's a good chance that it's with an administrative staff right now actually being uploaded.
Okay.
But I'll have to check up on that, and I'll be sure that you get it before the exam.
Okay, so are we going on the record or no?
You don't have to unless you need to for something. Sounds like he's gonna get the,
We don't
Yeah.
need to go on the record. As soon as I get discovery, I'll connect with my client and we'll be ready on December 17th.
okay, your client did sign on to Zoom, so she may be on here.
She is here. She's listening.
Okay, all right, no problem. Have a
Okay,
good day.
Thanks, you too. Bye-bye.
Thanks, everybody.
Bye-bye.
And Mr. Slusky, are you on the Gilbert Jordan matter? We need Mr. Bloomers.
Good morning, sir. Yeah, John has told me about that. Appreciate it, sir. Have a good day. All right.
Tammy, I might have to leave again.
Fine. I can't call any of the cases that I had ready until Mr. Bloomers comes back in from the breakout room. So
Oh,
do
I'm
what you
here.
have to. Are you there?
Yep.
Oh, okay. Let's get going then. Calling parties on Mahone, case number 2157778. The people of the state of Michigan versus William Mahone. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Count 3, domestic violence. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning, Judge. Richard Blanda for Mr. Mahone, 32990. He's on the call, ma'am.
Good morning to you as well, Mr. Blanda. Mr. Mahone, could you state your name, sir?
Yes, William Mahone.
Thank you. Good morning to you as well. Okay, today is the date time set for a PCC. Mr. Blanda, what's your pleasure here today?
Judge, I have yet, to my knowledge, I have yet to receive discovery, Judge. This is the initial PCC. We're asking for an in-court exam or another PCC date.
Well, as you know, the exam dates are pretty far out, so I certainly would anticipate that if there's any discovery issues that need to be remedied, they can be remedied certainly within the time frame between now and the exam. My only concern is, Mr. Bloomers, is there any issue regarding bond that might affect when the exam is set?
Yes, Judge. The people do have some concern with the bond. One moment. I believe that the defendant is currently on a personal bond with, it's a $150,000 personal bond with a no contact order. I had a chance to speak with the complaining witness in this matter, Lakita Robinson. She's very fearful of the defendant. Her house was shot up just this Father's Day, and it is being investigated with Mr. Mahone as a suspect. There was also another female individual involved in this case who was not charged in this case, but charged separately with a misdemeanor. She has been contacted variously by this individual. And I think given the nature of the offense here, which is a domestic and involves a handgun, which fired at the scene, I think there was an abuse of discretion in not ordering a GPS either, especially in conjunction with just a personal bond. So I think in order to ensure the safety of the community and specifically Ms. Rock, yes, Heather is the case.
Mr. Blanda?
Judge, as far as, all of this is brand new to me, Judge. But as far as the allegations that
Wait, hold on, Mr. Blanda. If you haven't seen anything, that can be remedied really quickly with the joy of being in this technological world, because I am going to address the concerns that are being raised. Would you like Mr. Bloomers, if you haven't already, can you push a button and send all of the information, at least the paper information, so Mr. Blanda can make an intelligent response?
Yes, Judge, and I did send the paper yesterday, but I'm sending it again right now.
That's fine.
I certainly don't want you to feel as though you're responding, Mr. Blanda, without being privy to at least the investigator's report. As I indicated, we're about to engage in a discussion here regarding bond. So if you'd like, I don't know if you've got probably 5 other places you need to be, but this is not something I'm going to pass on and as it relates to the bond.
All right, well, let me review that, Judge, and then I'll come back because I do have some circuit court matters I have to go to right now.
Certainly. And Mr. Mahone, I will need you to come back too. So I don't know if the two of you want to synchronize. It would need to be before 11:20.
Yeah, I have a trial at 11 o'clock, a bench trial. So I'll have to come back before then.
Okay. The two of you, Mr. Mahone and yourself, can coordinate as to when he zooms back in, and we'll recall it when we see your face appear.
All right, and I would just ask the prosecutor if he could send that paper discovery now, PDF. That's the only way I can read it at this point.
Okay, Mr. Blumers. Okay, thank you, Mr. Blanda. We'll see you in a moment.
Still there? I'm gonna call a couple other groups. Calling parties on Wells. Case number 2059515. The people of the state of Michigan versus Clifton. Lewis Wells. The defendant is charged with count 1, assault with intent to do great bodily harm less by strangulation. Count 2, domestic violence, habitual offender, court defense notice. Judge, this is scheduled for a preliminary exam at 11:30, but defense counsel wanted to see if they could switch it to a Zoom exam today.
Okay, appearances, please. Prosecution on Wells. Is that Mr. Bloomers?
Everything's Mr. Bloomers, yeah.
He may,
Imagine if we ever got to meet. We would be such good friends, best friends.
Advantage 2. Please your constant phone month-long. Advantage 2.
May I proceed?
No, we don't have the prosecutor.
how was this? Is he non-custodial?
He is non-custodial. All right, no, they called
Madam
that
Clerk,
one. Yes,
I sent you the amended info, so you should have that now.
I have it.
Thank you.
Do I have the parties? Mr. Simon, are you with us or are you still on the phone?
No, I'm with you.
All right. Calling parties on Wodorsky. Case number 2159104. The people of the state of Michigan versus Armand Breton Artisi Wodorsky. The defendant is charged with count 1, carjacking, count 2, assault with intent to murder, count 3, robbery armed, count 4, assault with intent to do great bodily harm less than murder or by strangulation. Count 6, weapons, felony firearm. Count 7, weapons, felony firearm. Count 8 and 9, weapons, felony firearm. Count 10, assault with intent to do great bodily harm less than murder or by strangulation. Count 11, weapons, felony firearm. Count 22, police officer fleeing third-degree vehicle code. Habitual offender, second offense notice. This is scheduled for a probable cause conference.
Thank you, ma'am. Appearances, please. That was.
Lauren Morales Smith, 83353 for the people, Your Honor.
Good morning, Your Honor. Jonathan Simon, P35596 for Mr. Wodarski.
Okay, and Mr. Wodarski,
Armand
present.
Wodarski.
Can you state your name? Can you state your name again?
Armand Wodarski.
Thank you. Mr. Simon, what's your pleasure here today?
Judge, has a date already been set, I think, for examination with co-counsel? I believe that's on the co-defendant. I think we already have a date. I would say that I had requested a video conference with Mr. Wodarski. I just received a message from the Sheriff's Department. Apparently the person who sets those up had been on vacation for a week, so I have to reschedule. There's also a pretrial service report recommending no change. I'd like to review that with Mr. Wodarski, perhaps when I do my video conference. And perhaps we could deal with both of those matters at the examination.
Okay, just for clarity's sake, Madam Clerk has confirmed that there is no exam date that has been set for the co-defendant. So we're
For either defendant.
well, yes, because you were asking to align with the co-defendant, but the co-defendant does not have an exam date. So what is your pleasure? Are you requesting, I know you say, I was listening, I know you said that you missed a video conferencing and you're going to schedule that and review the DSU report with your client. But in the meantime, what's your posture? Do you want to set another PCC or do you want to put this down for an exam date?
Well, I'd like to coordinate with co-counsel. Perhaps we can set another PCC date.
Okay, it looks like on the other matter, Vance, there's a new, is counsel here?
Judge, I'm here on that matter. I'm here for this, I'm standing in for the attorney on that matter.
Okay, is Vance here?
He's in custody.
Is Vance here though? I mean, is he on Zoom? I don't know. I don't know what he looks like. I'm sorry.
Jail.
We have to bring him in front of another video, so I couldn't call him at the same time.
Okay, I just
No,
wanted to,
I'm
I
just
just
letting you
wanted to know. So, Ms. Nance, if, just for purposes, we will call Vance separately because I think it's important for individuals who are in custody. Sounds like he's prepared to be before the camera. We'll call it separately. However, thank you for being here in lieu of the attorney of record so we can attempt to coordinate in terms of setting the next step, which from what I hear, Mr. Simon is saying, well, initially he did not think that there was co-counsel here, so we were trying to align with the co-defendant. But is the pleasure of the attorney for Vance to set this for an exam as well? Because we can go ahead and do that.
Judge Janecki Nance, P68686, standing in for the attorney of record, Arnie Chambers. The instruction that I was given was to go ahead and set an exam date, Judge. We wanted to see if we could get an exam date sooner because he's in custody as opposed to later.
I would concur. I did not realize Ms. Nance was here for Mr. Chambers. I would ask, she has Mr. Chambers' schedule that we also set it for exam for Mr. Chambers.
Do you have Mr. Chambers' calendar for which we can?
Yes, Judge, I have some dates that are, his earliest would be in August. I have some dates that he's available.
Can you shoot those out to us? What's the first?
Absolutely. Judge, he's available on August 11th. He has open availability.
Mr. Simon.
Not good. What else do we have? How about the 12th?
August 12th after 11 a.m.
Perfect.
How many proposed witnesses for the prosecution?
Your Honor, there will be quite a few. Right now, I'm thinking at least 4 or 5.
So that's not.
Oh, Paul, you better stop not looking at me when I look. No, I'm kidding. We're looking for an afternoon then, so just give us one moment. Is August 12th an option for one?
August 19th.
August 19th.
August 19th. Judge, August 19th is a good date for Mr. Chambers.
Yes, that afternoon is good for me as
Okay,
well.
I just want to ask that everybody mute their microphones. If there's someone who's not on this case that has a live mic. Wayne County Sheriff's Office, we need to be able to hear.
Can you hear us? Your Honor, he would like to speak to Ms. Nance in a breakout room real quick before
Okay,
this is decided.
we haven't even called his case yet. We're just trying to coordinate with the co-defendant, but thank you very much. I will put him in a breakout room in just a moment.
Thank you.
Okay, so Ms. Nance.
Yes,
just for
Judge.
confirmation, August 19th, you said, and that's a thumbs up.
That is a thumbs up. Yes, Judge.
Mr. Simon, August 19th at 1, a thumbs up.
I'm sorry, what time? 1:30 did you say?
1:30 due to the fact that Madam Prosecutor has indicated, well, I think the phrase was quite a few witnesses.
Yes,
So,
1:30 then on the 19th is good for me as well.
okay, and with quite a few, I'm not really sure how to receive that. That could mean we were gonna bounce into another day, but we'll just, we'll go with that and see how far we get. August 19th at 1:30. If there's any officer witnesses, I guess I'm starting to feel the need to say, which I don't think I should have to say, but please, if you could double check with your officer witnesses to make sure that there's no furlough or training. It's been a recurring issue that we've had lately with exams being set and prosecution not being alerted until the day of or the day before that officers are on furlough. These individuals are in custody and the matters need to be heard on the date that we're setting. So August 19th at 1:30. Now, if there's any discovery concerns, I'm going to hope that in the spirit of cooperation, that the discovery is tendered straight away without delay, including digital.
Your Honor, currently both parties have everything I have. I did receive Ms. Nance, I think she's going to put that on the record when her matter specifically is called. More requests for more information, so I'm going to be working on that list for her in Mr. Chambers' honor.
Perfect. Okay, so, Mr. Simon, is there anything further that you wish to address?
Well, there is a bond report, which recommends no change. It's $500,000, I think 10%.
And so, is there a question at the end of that? I don't know.
Well, I would like to review that with Mr. Wodarski. I think perhaps at a video conference from the jail. And if under the circumstances, we'll probably ask to have the matter put back on the docket another week or so for a bond hearing.
Yes, so Mr. Simon, you know I'm open door policy. So in the event that you review the report with your client and find that there's, some there that the court can consider in any motion that you might make, you certainly, I would just ask that you reach out to the prosecutor, reach out to Madam Clerk, and we'll tee it up for a bond motion in advance of the.
Yes, and the name of the prosecutor again, please?
Morales Smith.
Okay, yes, and I just did receive that report this morning, so I have not even seen it, nor have I had it over with Mr. Waters.
Additionally, Mr. Simon, I did send you the amended info, so you have that as well. And that has my contact information in it, should you need it.
Perfect. Okay, thank you.
Okay, perfect. Thank you so much, Mr. Simon.
Thank you, Judge.
And-
Thank you. Mr. Wodarski, we'll talk soon.
Miss Nance, I'm going to put you in a breakout room with your client, and then we'll call your case, okay?
Thank you, Judge. Thank you.
I didn't know he was there, Judge, or I could have done it probably at the same time. I'm going to, no worries. Do we have Mr. Bloomer's quick matter, and then we can.
I don't see him. I see his sign in, but I don't see him.
Mr. Bloomers?
Yep, I'm here.
Okay. Following parties on Lee, case number 2159024, the people of the state of Michigan versus Darmonte Keon Lee. The defendant is charged with count 1, home invasion, first degree. Count 2, larceny in a building. Count 3, domestic violence. Habitual offender, second offense notice. This is scheduled for probable cause conference.
Thank you, ma'am. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Robert Burton Harris, P81843 with the Neighborhood Defender Services of Detroit on behalf of Mr. Lee. Mr. Lee should be in your waiting room, Your Honor.
Mr. Lee, are you here? Because I actually have not enabled the waiting room yet. Mr. Lee, are you present in the gallery? Mr. Lee, going once, going twice? What's your pleasure, Mr. Burton? Did you want to request to waive his presence, or did you want to pass?
Yes, if you don't see him in your waiting room, we can I'll request to waive his presence.
Yeah, so I don't have a waiting room. I did not enable it yet. Yeah, so Mr. Wells? I'm sorry, Mr. Lee? Mr. Lee?
I see someone connecting. I don't know if that's him or not. No, that's another attorney. Okay, yeah, I'll ask your permission to waive his presence then.
Okay, so ordered. And what's your pleasure today, Mr. Burton?
So this is a probable cause conference, Your Honor. I don't have any discovery in this matter, so I would like another probable cause conference, if possible.
Sure. What about August? You want to pick a date somewhere roughly 30 days out? You know your calendar better than me, so I don't want to just.
I have a couple matters scheduled with you on the 9th. Will the 9th be okay? August 9th?
New PCC is going to be August 9th at 8:30 via Zoom. Prosecution, can you get that discovery to Mr. Burton?
Yes, Judge, and my records do show it was sent to NDS's Central Discovery back on the 7th, but I will send it directly to Mr. Burton Harris today. And before the court asks, there are no concerns as to bond at this time. The people are satisfied.
Well, I have a couple concerns, Your Honor. First of all, as far as discovery is concerned, was digital discovery sent or just paper discovery?
Just paper.
Okay. Well, I need the digital discovery also.
Right.
And as far as the paper is concerned, for whatever reason, my office is still getting redacted discovery. And there's a Court of Appeals opinion that I think I've put on the record a couple of times now that said that we're entitled to unredacted discovery. And this isn't just redactions as far as witnesses' names, this is entire pages redacted. So I need a copy of the unredacted discovery if that hasn't been provided. The other thing, as far as the no contact, Your Honor, I think that Your Honor has jurisdiction over any witness in a case. And I'm asking that Your Honor enter a no contact order directed at the complainant in this case. This is the third or fourth time that this complainant has made accusations against my client. She never comes to court after she makes these allegations, and she won't stop contacting him. So I'm asking Your Honor to enter an order for the complainant to stop contacting my client.
Wow, now that's interesting. So I am going to deny that motion to enter a no contact from the complaining witness to the defendant. The charges against your client, certainly the court does have discretion in certain matters, but I'm not going to place an order, a no contact order on the complaining witness, notwithstanding what you represented. However, I will say to Mr. Bloomers, which I always say to the prosecution, your complaining witnesses, particularly in a situation where there's an allegation of domestic violence, should absolutely not have contact with the defendant. They should not be gaslighting. They should not be even reaching out in a pleasant way. But the key word there is should not. There is not an order, a no contact order, but again, the court does, treat that pretty seriously. And I know that the prosecution has indicated in the past that they do have those discussions with their witnesses. So I'm hoping that will happen in this matter as well. Sounds like perhaps maybe you should talk to your client about filing a police report for something related to the complaining witness, but that's a whole nother issue. I'm sure you probably already discussed it with your client, Mr. Burton, as you are an excellent attorney. So with that being said, the first issue though, you raised, regarding unredacted discovery. Mr. Bloomers.
Well, the standing order here is still to send the paper discovery redacted, so that's what I'm going to do. If there's, if Mr. Harris wants to file a motion or something, we can do that, but I can't contradict the standing order from my supervisors from the office as a whole. My understanding is there are emergency appeals of this decision being filed because witnesses are killed over this stuff all the time. So I don't know why, I think that court appeals opinion was issued in haste and without really giving thought to what happens when you give all this personal information out to defendants, but that's neither here nor there. The point is I don't have the discretion to give that out unredacted. I've looked through the discovery and there are not any whole pages of redacted information. And I would guess that probably is happening in error if that happens at all. I don't know why a whole page is redacted, but it's not in this case. So I have sent the redacted discovery.
Hold on, Mr. Bloomer, on your last two sentences, Mr. Bloomer,
yeah,
your audio dipped. And so Madam Court Reporter is challenged because she's trying to get every word you say. Can you just repeat the last two sentences? That's it.
I think it was just that I don't know why a whole page would be redacted from discovery. I would guess that probably happened in error, but it has not happened in the discovery in this case because I've reviewed it. So I have sent the redacted discovery, and that's as much as I can do at this point.
This is amazing. Can I address that, Your Honor?
Yeah.
This amazes me. There's absolutely no basis in law for a prosecutor's office to have some standing order that supersedes a published Court of Appeals opinion. Mr. Brother Counsel is an attorney. I mean, he's under obligation to follow what the Court of Appeals has said. I don't know why this is still a thing. To actually expressly say that my office has an order that somehow supersedes the Court of Appeals opinion that's published is mind-boggling to me. So at this point, Your Honor, I don't feel like I need to file a motion for the prosecutor to do what the Court of Appeals has told him to do. So if I don't get the redacted discovery, I mean, I guess I would have to file a motion to compel. But I mean, at this point, I think that would kind of be a waste of time because Your Honor has all the information that you need to tell the prosecutor's office to give me what the Court of Appeals said I'm entitled to. or my clients
I
are
mean,
entitled to, I should say.
If you don't get the unredacted, you said redacted, but, so Mr. Bloomers, I'm gonna ask you to do this, if you could. And I appreciate you always show a level of cooperation, Mr. Bloomers. Let me first say that. If you could speak with your supervisor regarding this decision, and if there is an issue, with providing counsel with what he's requesting here pursuant to that order, then I want the parties to come back to Zoom. And I want us to discuss this further. And I would like a copy, if you could forward a copy of that opinion to me, Mr. Burton Harris. I would greatly appreciate that. But the step I'm asking for you to do, Mr. Bloomers, is to reach out to your supervisors, because this is going to be a recurring issue. And I just want, there to be a representation, a solid representation from the prosecutor's office as it relates to this request. So please, if there is an issue, I want there to be some communication back to the court and to Mr. Burton Harris. And likewise, Mr. Burton Harris, if you could forward a copy of that opinion, I would greatly appreciate it.
I will, Your Honor. It's the case is People v. Ricky Dale Jacks, I believe. And just for clarification, you don't want us to come back on Zoom today, but at the probable cause conference to address the redacted.
Yes.
Okay.
Yes, if there's an issue, there may not be an issue. Mr. Bloomers may go back and talk to his supervisor, it may be a non-issue. But either way, we will reconvene on the date that we said. I think it was August 9th, correct?
That is correct, Your Honor.
At 8:30 via Zoom, and then from there, we will determine.
How are you?
From there, we will.
Okay,
Body
thank you, Your Honor.
cam yet for
I appreciate
Jelani
it.
Shakur. Today's our first.
There we will determine where we're going. Okay, thank you.
Thank you, Judge.
Okay. What do we have in the courtroom here? Okay.
You don't.
Larkin.
All right, thank you.
He's right here.
Is there witnesses?
Oh,
Mark. All right, so
I didn't hear. Are they?
I believe so, yes.
I'm back on Mahone, ma'am.
Okay, and I don't know if we can
Bring Larkin out.
We are ready on Randall when you can, Your Honor.
Can you get your first witness in position, Madam Prosecutor? We're getting ready to call this. Oh, thank you.
Can I call Randall while we're doing that?
Sure. Is it good? I mean, it's your jail. Oh.
I'm ready on Mahone.
I hear you, Mr.
Good morning. I have the
Brandon.
waiver. Is that Mr. Page in the Division 1, Your Honor? No, that's Mr. Randall.
Yes, this is Mr. Page.
Yeah, Mr. Page, and I have a waiver for Mr. Page.
Calling parties on page. Case number 2159068. The people of the state of Michigan versus Jordan, Cornell Page. The defendant is charged with count 1, police officer fleeing third-degree vehicle code. Count 2, police officer assaulting, resisting, obstructing. Commission of a felony with a motor vehicle advisory. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Very good morning, Your Honor. May it please the court, Sharon Clark Woodside, appearing on behalf of Mr. Page. My bar number is 41295.
Good morning to you,
Yeah, I
Ms.
did have an
Woodside.
opportunity to meet with Mr. Page last evening in the Wayne County Jail. He has given me his consent to execute a waiver. He understands he has a right to a preliminary examination where the people would have to show the offenses charged were committed and there's probable cause to charge him with the offenses. He wishes to waive the preliminary examination and be bound over to the circuit court. And then I'd ask the court, may I address bond?
Okay, Mr. Page, could you state your name?
Jordan Page.
Is there any objection to the proposed waiver?
There is no objection to the proposed waiver, Your Honor.
Okay, Mr. Page, I just need to ask you a few questions, notwithstanding what Madam Defense has just said. Do you understand the allegations against you, sir?
Yes.
You understand you have a right to a preliminary examination?
Yes.
Understand that if an examination were to proceed, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit and county of London, that you probably committed those crimes. Do you understand that?
Yes.
If the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process?
Yes.
Now, the representation has been made by your attorney that you would wait to give up your right to preliminary examination. Is that true?
Yes.
Bound over to the circuit court for further proceedings without the benefit of an exam at this phase.
Yes.
Is that what you wish to do?
Yes.
Doing voluntarily, sir, on your own? Is anyone threatening you to do this, or?
No.
Are you doing this? Are you doing it voluntarily?
Yes.
Thank you. Okay, I do have the examination waiver form that's been returned to the file that's properly executed. I do find your waiver to be knowingly and voluntarily given. The matter is now bound over to the circuit court for further proceedings with an AOI date of July 21st. Esteban?
Is Mr. Page's bond 10,000 personal?
It is a $10,000 personal bond.
Okay, then I guess I don't need to address bond if he has a personal bond.
He must have.
I'd have to ask the jail if there's any holes.
Okay.
I do know that this stemmed out of a warrant for a violation of parole. So it might be a parole hold.
Okay.
All right, thank you so much, Ms. Woodside. Mr. Page, good luck, and I think we're all set here.
Your Honor, I'm so
Okay,
sorry.
thank you.
For the arraignment.
The arraignment, July 21st.
Thank you.
Okay, so Mr. Page, I have to find out what the status is about that, okay? I'll let you know.
All
Thank
right.
you.
Would you ask me? Mahone, did I hear someone say they were ready? Yeah.
Yes, Judge, I'm home, ma'am.
People versus William Mahone, 21057778. Appearances, please.
Jacob Bloomers on behalf of the people.
Again, Your Honor, Richard Blanda, 32990 for Mr. Mahone. He's on the call. Sir, give your name.
William Mahone.
Judge, I've had an opportunity to review the investigator's report in this case. And what's indicated to me, Judge, is that this alleged incident occurred back in December of last year. It appears that the parties have a child together, at least one. The allegation is that Mr. Mahone came over to the home requesting the child, that there was an altercation. He then left and allegedly fired a shot into the air. The police arrived, Judge, found no casing in the street. There have been no other incidents since December 11th, 2020, to my knowledge. And as a matter of fact, my client indicated to me, because I spoke to him in the interim, is that according to him, there's a warrant out currently for the complainant in this case for having destroyed his home on Father's Day or a couple of days before that date. That's what he's indicated to me. So again, there's been no other incidents that I'm aware of with respect to him.
Excuse me, he shot her house up. He sent the girl over to shoot her house up on Father's Day.
Mr. Bloomers?
Yes, Judge.
That's not true.
It's recent and it's been investigated by the police, Detroit police, the 2nd precinct.
Okay, hold on.
It was just recently documented down, I believe, the 17th?
Okay, so here's something that I was remiss in stating at the beginning. I guess I kind of feel like I don't need to say it anymore, but let me just pull back. Good morning to everyone that's here on Zoom and that may not be familiar with Zoom court, but it is tantamount to being in the courtroom. So my expectation is that everyone would conduct themselves as if they're actually inside of a courtroom. And let me just go through the whole course of what I would typically say, and that is that my expectation is that if you're talking, A, that you should be talking, B, that I know who you are, C, that your camera's rolling, D, that you're wearing clothes and that you're properly clothed. And E, that there's no use of any profanity or any outbursts that are not in accordance with the hearing that we are conducting. So now I'm not sure who's talking, what the relationship is to the case. Mr. Bloomers, is this the matter in which you went to a breakout room with the complaining? Is this the complaining witness?
No, I don't believe so.
Do you know who this is talking?
No, Your Honor.
Okay, so.
Judge, I have no idea who, I have no idea who was just talking.
What, Glenda? Just one second. Do you want to identify
Excuse
yourself?
me, Your Honor. Excuse me, Your Honor.
Hi, so did you want to identify who you are? Okay.
My
Mr.
name is
Glenda.
Sarah. I'm a witness for the shooting that happened on Father's Day.
Mr. Bloomers, I need to start an examination. It sounds like there's some information perhaps that, I don't know if you need to speak with this particular individual or.
Well, no, I did get, I'm sorry, Judge, I did get that information from the complaining witness already. I don't need to speak with that witness at this time. That's regarding a different investigation. But I did mention that in my initial argument for bond, or for the tether.
So I'm going to ask, and I do this with the utmost respect. I'm going to ask whomever is the third party that's speaking, that if you are going to be present in the Zoom gallery, that you mute your microphone. With that being said, we're addressing the issue of bond. There are concerns that have been raised to the extent that Mr. Bloomers, I believe, is requesting that, if my memory serves me correctly from earlier, that you're asking for a GPS tether to be added to Mr. Mahone's bond. Is that correct,
Yes, Judge.
Mr. Bloomers?
Yes, Judge, that's
And
correct.
Have indicated already, I don't think we need to rehash it. You have already indicated your posture to that request. Was there something additional you needed to add, Mr. Glenda?
No, Judge, other than what I've said.
Okay, thank you so much. So what I am going to do, and honestly, I don't like to get in there and jiggle around with bonds that are set by the arraigning magistrate, but I do it, and I do it when it's appropriate, when I feel as though there's an abuse of discretion. On a matter like this, to set a $150,000 personal bond in a domestic, an allegation of a domestic situation, to just simply say no contact and not impose a GPS tether under these circumstances, an assaultive offense with the alleged weapon being a pistol, I am making the determination after reviewing this matter that it was an abuse of discretion in not imposing a GPS tether. So with that being said, I am going to add a GPS tether. Your client is going to be instructed to telephone the number that we will have on the form today. It is not optional. It is mandatory. It is not something that I'm doing to penalize him. It is a precaution courts use, Mr. Glenda, as you know, to ensure that there is no contact. In this sort of a situation where there's an allegation of domestic, there is a heightened concern, a heightened level, a heightened temptation, if you will, to reach out in an attempt to use the tether as I am going to impose that, and that is something that should have been imposed, particularly if there was a personal bond being imposed. There should have been a tether that was imposed for the second prong of that bond analysis, which is the safety of the community, in particular, Ms. Robinson. So what I'm going to do is I'm going to write that order up right now. It's going to be forwarded to defense counsel and the prosecution. Again, it will contain a phone number for which your client must call to get that tether attached. And obviously the no contact is in place. I'm only going to reiterate the following because many times people are confused. I don't know what happens at the arraignment because I'm not party to it, but many times people don't understand and they find themselves in hot water. No contact really means no contact. It means no direct contact. It also means no indirect contact. For instance, You cannot write a letter, telephone, text, any form of social media, nor can you have anyone, Mr. Mahone, act on your behalf to reach out to the complaining witness. That would be considered a violation. Another thing that you should be aware of is even if the complaining witness comes to your doorstep, that doesn't then give you permission to suddenly engage with the complaining witness. You are not to engage with the complaining witness. If there's some issues, we just had it on a case 2 cases ago. If there's some issue wherein you feel, Mr. Glanda, that your client may need to file a police report the opposite direction, then so be it. But in this particular matter, the bond that Mr. Mahone needs to be concerned with is his own. And I am again adding the GPS tether to include no contact with the complaining witness as well as her residence. Do we have an exam date that we've set already? I don't
No,
believe
Judge,
so.
we're asking for an in-court exam.
In-court exam, if we could do it sometime, since the Cutter's being imposed sometime in September. Mr. Prosecutor, while she's looking up a date, please make sure you reach out to your complaining witness to also indicate and advise that they should not be doing anything to gaslight the situation. Reach out to the defendant. Although the order is not on them, they should certainly refrain from reaching out to the defendant.
Yes, Judge.
Or first week in October.
Judge, we can do September 30th at 10 a.m.
Mr. Glanda?
That's not a good day, Judge.
Okay.
October 1st at 11:30.
No, that I'm starting a trial in Oakland County Circuit Court on Friday, October 1st. If I can suggest the 5th or the 7th of October.
Okay, the 5th at 11 a.m.
That's fine. Thank you very much.
In-person examination, October 5th at 11 a.m. And that amendment to the bond is to be forwarded straight away.
I'll contact you, Mr. Mahone, once I get that order.
Mr. Bloomers, do I have permission to sign your name to the motion to amend the bond?
Yes, Judge. Thank you.
Thank you.
We need to start, but I don't know if they want to change that. If Mr. Wells is on there, to change that to a Zoom thing.
Mr. Bloomers, did you anticipate witnesses on Wells?
We're all set, right, Tammy?
Yes.
Mr. Bloomers, can you hear me?
I have had no contact with the complaining witness, so I'm not really anticipating witnesses, but I don't have confirmation of not coming.
Okay, well, I guess we can call it. Do I have?
I think you have it.
People versus Wells, this is a recall, 200-59515. Appearances.
Jacob Bloomers on behalf of the people.
Good morning. May it please the court. Jennifer Colthurst, P52876. I appear on behalf of Mr. Clifton Wells. Mr. Wells, please unmute.
I'm here.
Please state your name.
Clifton Wells.
Counsel, Ms. Colthurst.
Your Honor, today is a date and time for a preliminary examination. We were scheduled for an in-person hearing at 8:30. My client has recently suffered some type of vandalism to his vehicle. He's respectfully requesting an opportunity to have an in-person, a Zoom examination, if the people are ready.
Okay, you don't mean today though, right?
Yes.
Okay, well, the problem, with that is that, of course, we assume that everyone is on the same page and is technologically, up to speed with things, to the moment, but not everybody is. So I'm certainly fine with the prosecution has no objection. I'm fine with amending it to a Zoom, but not today, not this morning, on the date of the exam. On the off chance that perhaps the complaining witness is not as technologically savvy and not up to speed with their memos and emails, I would hate to make this conversion and for some reason they end up here. So yeah, certainly I'll amend it to a Zoom, but we have to select a new date. Okay? What's your pleasure?
Do you understand that, Mr. Wells? Do you want a new date or do you want to figure out how to get to the courthouse?
I can call a ride to get to the courthouse. I do not want to do a new date.
Your Honor, it appears that Mr. Wells will figure out how to get to the courthouse. And therefore, we do not need a new date.
Did you need something? Are you on this case?
No, I'm just.
I see you
waiting
looking
for
at me. Okay. All right.
So we'll see you later on this morning. I'm still tied up as house counsel at the court, but I'll get there eventually.
Okay, and this is all with the caveat that what Mr. Bloomer said on the record. I'm not going to repeat what he said earlier regarding witnesses. No, yes. Okay, we'll see you at 11:30. Thank you.
Thank you.
I don't know.
I don't know that she was paying attention to that.
I don't know what's going on with the jailers, but.
Let's just call this case here.
Calling parties on Larkin, case number 21-58465, the state of Michigan versus Tony Derek Japhius Larkin. The defendant is charged with count 1, weapons, firearms, possession by felon, count 2, weapons, ammunition, possession by felon, count 3, weapons, carrying concealed, count 4 and 5, weapons, felony firearm, habitual offender, court defense notice, commission of a felony with a motor vehicle advisory. This is scheduled for a preliminary exam.
Okay, before you put appearances on, could I trouble you though? I'll call her. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court. Edward Martell, P85051 of the Perkins Law Group on behalf of my client, Tony Larkin. Mr. Larkin, please state your name for the record. Your Honor, I'm also joined by my co-counsel, Attorney Jamonte Cannon, also of the Perkins Law Group.
Good morning, Your Honor. Good morning, honorable court. Jamonte Cannon, Perkins Law Group, P82992. Here to assist Attorney Ed Martell, here on behalf of Mr. Tony Larkin.
Thank you. Where is your tie?
Our apologies to the court, Your Honor.
Oh, before we start this other, is credit a waiver or a dismissal?
Dismissal?
Can we do?
Yeah, absolutely.
Do I have the attorney in here for that?
Yeah.
Calling parties on credit, case number 21-58891, the people of the state of Michigan versus Darius Credit. The defendant is charged with count 1, weapons, firearms, possession by felon, count 2, weapons carrying concealed, count 3, weapons, felony firearm, count 4, police officer assaulting, resisting, obstructing, habitual offender, court defense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Emily Elijah with Neighborhood Defender Service, P85039 on behalf of Mr. Credit.
And Mr. Credit?
Mr. Credit is over here.
So you Darius Credit.
Okay, can you say it loud enough for this young lady?
Darius Credit.
Thank you. Okay, today is the date and time set for a preliminary examination. This matter was set for 10 a.m. It's currently 10:10 in the morning. Are we proceeding to an examination?
We are not, Your Honor. The people are going to be dismissing this case without prejudice due to the federal government's involvement with this case. They have a valid complaint and arrest warrant that I will be forwarding to Ms. Elijah, here in a couple of moments.
Okay. I'm assuming there's no objection from the prosecution in that regard?
No objection from defense.
Or, I'm sorry, defense. I'm sorry, yes, Ms. Elijah.
Thank you.
With that being said, do you understand what's going on here, Mr. Credit?
No.
Your matter is getting dismissed on this level, but the feds are picking it up. So Ms. Elijah is going to be in contact with you once she receives that information.
So when do I go here to the fed?
Yeah, and I don't really know exactly how soon that process will occur, but I would imagine it will be probably rather swift.
All my paperwork and stuff, I thought you basic work, I ain't grabbed none of my stuff.
And Your Honor, if I may,
Yes.
this is the first I learned about this actually happening today. We weren't sure if it was going to happen. So is there a space? Can Mr. Credit go back downstairs so I can talk to him in the attorney booth downstairs? Okay, so I'll talk to you downstairs, okay?
And just for the record, Your Honor, I did not hear of it until about 9:30 this morning.
Okay, perfect. I will need your signature, Madam Prosecutor, as you're the moving party on this order of dismissal. The matter is dismissed without prejudice.
And does the court need my signature?
No.
Thank you, then I'll go downstairs. Thank you, Your Honor.
Thank you.
Thank you.
Oh, but Miss Elijah, you will get a copy if you wanted to come back up and get it or wait for it. It'd probably take a few minutes because we need to get signatures and then fill out, process it.
I will return to pick up that copy.
Okay, thank you.
Thank you, Your Honor.
All right. Back on the record in the matter of People versus Larkin, are there any preliminary matters to tend to? This is 2105845. Did you want to put your appearance on real quick, Ms. Bailey? Counsel, did you want to put your appearance on, counsel?
Sure, just for the record again, Edward Martel, P85051, on behalf of Mr. Larkin. Your Honor, if I may, just for clarification, Attorney Cannon is just joining me today for the limited role of playing the audio video to which parties have so stipulated.
Oh, okay, all right. With that being said, put your appearance on, please, if you would. Ms. Bailey?
Oh, Bryn Bailey on behalf of the people, P84009.
Thank you. Sir, your name?
Tony Larkin.
Thank you. All right, any preliminary matters?
Yes, Your Honor, two. The first being that Mr. Martel and I have agreed to stipulate to the prior conviction of carjacking, which with a sentencing date of September 29th, 2015 for the purposes of preliminary examination. And then additionally, the people have also agreed to stipulate to the, I believe you asked about the body worn?
The audio video, the body cam stop car audio video.
We have agreed to stipulate to that for purposes of preliminary examination only.
Okay, those two stipulations will be received as it relates to the prior conviction that you specified, as well as the admission of the body cam. Any other preliminary matters?
Nothing further for the people.
Mr. Martel?
There was a discussion regarding maintaining Mr. Larkin's writ, but I will leave that for the conclusion of this hearing.
Thank you. First witness?
Yes, Your Honor. At this time, the people would call Officer Eugene Capiche.
Ms. Bailey, on that order of dismissal, did you add in the language that the feds are picking the case up?
I did not, Your Honor. I will do
Put that in the other category.
Your Honor, if I may?
Yes.
Do you think request a sequestration order?
Sequestration is granted. Is there an officer in charge present?
He is outside, not in the courtroom.
Do you wish him to be present?
No, Your Honor, that's
Thank
fine.
you. All right, sequestration is granted. I'm going to shut down, well, the courtroom is already shut down basically from any spectators due to the COVID restrictions. The only people in the courtroom are those on this immediate case and those working the courtroom. I am going to shut down the Zoom gallery. And the only individuals remaining will be those that are attorneys. The third tier to sequestration is that this is live streaming on YouTube. So if there's anyone watching, Mr. Mahone, I think we're all set on your case, sir. We're all set on your case. Yeah, if you have any questions, please make sure you contact your attorney, okay?
All right, thank you.
You're welcome.
So I need.
If there's anyone watching the live stream, if you are a witness or a potential witness in this matter, now would be the time to stop watching to maintain the integrity of this process, as it may preclude you from testifying in the future. Any other preliminary matters before your first witness?
No, Your Honor.
Okay, please call your, is your first witness here?
Yes, Your Honor, this is Officer Ibrahim Kakish.
Good morning to you, sir. Could you please state your full name and spell your first and last name for Madam Court Reporter?
Yes, good morning, Officer Abraham Kakish, Ibrahim, last name Kakish, Kakish, badge 854 out of the 6th precinct.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. If you come around this way, there's a half gate that opens up towards you. And watch your step coming up those stairs. And please, once he's settled, Madam Prosecutor, you may proceed.
Thank you, Your Honor.
Maybe I'll just pull the microphone down.
Good.
Please proceed.
Good morning. Could you please restate your name for the record?
Abraham Kakish.
Now, you mentioned that you were part of the 6th precinct. Is that the Detroit Police Department 6th precinct?
That is correct.
In what capacity are you employed with the DPD?
I work with the Special Operations Unit.
How long?
6-7 months, but I've been employed with the Detroit Police Department for roughly 5 years now.
In what capacity were you, oh, never mind. Were you employed in that capacity on June 1st, 2021?
I was.
Did you in fact work that date?
Yes,
Were you by yourself or with a partner?
with a partner.
What's your partner's name?
Officer Leonard,
Could you please spell Officer Leonard's last name?
Leonard.
Were you in full or modified uniform?
Special Operations approved uniform.
So would that be something similar to what you're wearing today?
That is correct.
And for the record, that is a black polo with your name, a DPD badge, and I believe I saw you wearing green pants.
Correct, green pants, and now we have the outer carrier. It also has my badge and name.
Were you and your partner on foot or in a scout car?
Scout car,
Was the scout car fully marked or something else?
semi-marked.
Did your duties as a police officer take you to the area at or near 19599 Plymouth Road?
Yes,
Is that location in the city of Detroit,
yes.
Wayne County? What is at that location?
There is a green light gas station. I believe it's a mobile.
What brought you to that location?
On routine patrol, observed a vehicle traveling at a high rate of speed, windshield tinted, and then
I'm sorry, going at a high rate of speed of what?
and the windshield was tinted. Caught up to the vehicle to conduct a traffic stop. Vehicle then pulled into the gas station where the traffic stop was initiated.
And how fast was the vehicle going when you first observed it?
Don't know the speed, but it was traveling greater than the, it was fast, it was traveling faster than the cars that were
On Plymouth?
yes, yeah, it was on Plymouth. You can see the vehicle pass other cars going westbound.
And after you effectuated the traffic stop, what, if anything, did you observe?
As we initiated the stop, it was occupied 3 times.
I'm sorry, say that one more
It was
time?
occupied 3 times. The vehicle was occupied 3 times?
So there were 3 people in the vehicle?
Yes.
Okay.
I'm sorry, did you say the vehicle was speeding or the vehicle was just going faster than the other cars?
No, it was traveling at a high rate of speed. And then the windshield was also tinted.
So after observing 3 people in the vehicle, what if anything did you do?
Approached the driver, requested a valid driver's license, which he failed to provide, and or an identification card.
Did the driver have an identification card?
I don't believe so, no.
Do you see the driver here in the courtroom today?
I do.
Could you please,
Your Honor, defense law stipulates identification.
I'd like for there to be an identification. Thank
Yes,
you.
Your Honor.
could you please point to the person you saw driving this vehicle and tell me something that they're wearing?
The gentleman that's sitting over there with the green jumpsuit.
Your Honor, may the record reflect that this witness has identified the defendant?
The record will reflect identification of the defendant.
So what, if anything, did you do after asking for identification?
Which he failed to provide, then after I exit the vehicle, as I was going to place handcuffs on him, I asked him if there was anything on his body that was gonna poke me or stab me. He said not to poke you.
Your Honor, objection. As to voluntariness of the statement, I would like the opportunity to voir dire the witness. Knowingly, intelligently, and voluntarily. Voluntariness of the statement, excuse me.
Sure.
Good morning, officer.
Good morning.
I'm going to ask you a couple questions regarding the statement that was made by my client, allegedly purported statement. And if you don't understand, please let me know, and I will clarify for the record. Okay? Okay. Now, you stated that he did make a statement on that day, correct?
It was a simple question, which he did make to me, yes.
Okay. Now, prior to making that statement, obviously you stated that he was, you were in the process of placing him under arrest, correct? He was under arrest?
Putting him in cuffs, pending
Okay,
further
we're putting him in
investigation.
cuffs.
I'm sorry, please, counsel.
Yes.
One at a time.
Please, go ahead. You were putting him in cuffs, or you put him in cuffs?
I was in an attempt to put him in cuffs, asking if there's anything on his person.
Okay, and you were dressed obviously in that marked uniform at that time? Correct?
Yeah.
And you had a gun on your side?
I did.
Okay, and he was not free to leave at that time, correct?
No.
Okay. Your Honor, based upon this, my client was obviously in custodial, it was a custodial arrest, and obviously any questions or information elicited from it at that time was an interrogation. For that, Your Honor, I would ask that the statement be suppressed.
Well, the prosecution, I'm assuming, has a response to that.
Your Honor, if I may continue briefly?
Sure. Wait, are we talking about the question about whether or not he had some, okay, I'm sorry, go ahead.
And obviously you offered him Miranda at that time, correct?
Sorry?
Obviously, prior to any eliciting of questioning, you offered him his Miranda rights and Miranda warnings at that time.
No, because he was not under arrest at that time.
Okay,
He was detained pending further investigation.
Okay, but he was not free to leave, correct?
Like any other traffic stop, they're not free to leave until they're completed with their traffic stop.
Again, Your Honor, based upon no Miranda, custodial arrest, and the interrogation, I would ask that the statement be suppressed.
Your Honor, I don't believe that Miranda requires the suppression of such a statement or a response to a question as it is for the safety of everyone involved, Your Honor. And asking if someone has something that could possibly injure another person is not necessarily an incriminatory statement.
Thank you. Objection is overruled. Unless I'm missing something about what comes next, which I'm not as familiar with the case as you are, the objection is overruled, given what the question that the officer indicated he asked and was about to say what the defendant indicated as a response. The objection is overruled, but it's noted. Please continue.
Thank you, Your
Please
Honor.
continue, Madam Prosecutor.
Thank you, Your Honor. So, officer, you'd asked the defendant to step out of the vehicle. What, if anything, happened after you asked him to do so?
asked after we had him step out the vehicle.
Yes, sir.
That's when I asked him if there was anything on this person that was gonna poke me and stab me, as I was patting him down real quick. And then he said, not poke you, and then as I felt to the right side, I felt the L shape, or I felt the object reflected as a firearm in his right pocket.
And at this time, was Mr. Larkin already in handcuffs?
I honestly don't recall.
Okay. So after.
I don't believe so, actually, no, because I requested for an additional unit before
Before you.
Put him in
finish, before you what?
before I put him in cuffs.
Thank you.
Thank you.
That's right.
So after, this statement and feeling the item yourself, what if anything did you do?
I had an additional unit to make the location, detained all the parties till we verified that the passenger of the vehicle had a valid CPO, which I was not privy to until towards the end of the investigation.
Okay, so what type of gun did you locate?
It was a handgun.
And after you located it, what, if anything, did you do with the handgun?
It was placed in the scout car. It was made safe, placed in the scout car. Driver was then taken with us. Dropped off at Detroit Detention Center. The firearm was then placed on evidence at the 11th precinct.
And did the defendant provide you with a concealed pistol license?
He did not.
Did the defendant indicate whether or not he had a concealed pistol license?
He did not. And per talent, he did not possess a concealed pistol license either.
What is talent?
The LEAN, the law enforcement computer network system.
And when a gun is found on the scene and taken into evidence, what, if anything, is done with it?
Driver goes in our custody, we take it to the 11th precinct and do the proper paperwork. The evidence tab, the firearms report, and the actual report all goes with the firearm in the envelope and left at the 11th precinct with the front desk supervisor.
Do you know if the gun was loaded, unloaded, or something else?
From what I recall, unless I can recollect from my report, the firearm did have a magazine containing live rounds in it. Unknown if there was one round in the chamber or not.
You said unknown?
I mean, I'm not too sure unless I can recollect from my report.
Would looking at your report refresh your recollection as to if the gun was chambered or not?
Yes.
Your Honor, permission to approach the witness with his report for recollection refreshment?
I'm assuming the defense has a copy of it, so yes.
They do, and I will also be showing them as well before approaching. So officer, what I would like you to do is to review your report silently and look up at me when you're done, okay? All right, will you turn the report over in front of you? Thank you, sir. Does that refresh your recollection?
It does.
Was there ammunition within the chamber?
Yes.
And how many rounds of ammunition were recovered?
One round was in the chamber and then a magazine containing live rounds. We did not remove the rounds from the magazine.
When placed onto evidence, is the gun and the ammo two separate pieces of evidence?
No, it all goes together.
So they would have one evidence number.
Correct.
Do you recall that evidence number?
I could have looked at my report.
Is it written on your report?
I believe so.
Your Honor, permission for the witness to look at his report to read the evidence number into the record.
Yes.
Tag number 656308-1.
Thank you. Your Honor, I have no other questions at this time.
Your Honor, if I may.
Yes.
Good morning again, officer.
Good morning.
Okay, so again, I'm gonna ask you a few questions. If you need any clarification or do not understand those questions, please let me know. I will rephrase. Generally, my questions call for a yes or no answer. Agreed?
Agreed.
Okay, so you said that on the date of June 1st, that you were working in the capacity of special ops, correct?
Correct.
And you've been in special ops for approximately 6 months, correct?
Roughly 6-7 months, yes.
Okay.
please keep your voice up.
Yes, roughly 6-7 months, if I believe.
Okay. And within those 6 or 7 months, you've been in there 6 or 7 months. So within those 6 or 7 months, how many infractions similar to say speed, traffic violations have you, on average, effectuated?
Are you referring to tickets?
Yes.
All depends, some days we're at 30, 15, depending on the day, depending on our, what our objective is.
Okay. And what is your objective for special ops, please?
The high capacity of proactive policing.
Can you elaborate on that a little bit for the court? Guns, drugs?
Guns, drugs.
Okay, so many of these traffic stops that you make eventually lead to guns and drugs, correct?
They do.
Okay. Okay, so you were in a semi-marked vehicle, correct?
Yes.
Okay, and that would be, can you elaborate on that a little bit? Is that the standard black police SUV?
Yep, black SUV, with the lettering of Detroit Police on the side of the sticker.
Okay, would I be correct in stating that the letters are also black, correct? So black on black on black?
Like a matte black, yes.
Okay, and so you were parked in a fixed position on Warren Avenue, correct? Or not Warren, but Plymouth Road, correct?
I came out the station and I was parked facing northbound on Warwick, ready to come on to Plymouth.
Okay. Okay, and you said that you, and correct me if I'm wrong, but you said that you, at this point in time, you've seen my client or the Lincoln MKZ drive by at a faster rate of speed than the flow of traffic, correct?
That's correct.
But you could not tell how fast he was going, correct? Correct?
That's correct.
Okay, so the faster rate of speed, how many cars would you say were on the road at that time, officer?
About 3 cars, 3, 4 cars.
And could you tell how fast? You said 3 or 4 cars.
Mm-hmm.
Okay, and you were
Is that a yes?
obviously, yes?
Is that a yes? Okay, so when you say, it's difficult for her to pick it up. So was that a yes?
Oh, sorry, yes, there's roughly around 3 cars.
Okay, and you obviously had scout car and body camera access that day?
Yes.
Correct? And there hasn't been altered in any way, correct?
No.
So if I showed you today your video and it said differently, would you like your video to refresh your memory, please?
Please.
Your Honor, ma'am?
Yes.
Okay. Mr. Cannon, please.
Oh, wait, I'm sorry.
You can't do that.
Oh, sorry. I would like to present the video to the court and to the officer to
Okay.
refresh his memory.
We just can't interrupt this because it shuts down the live feed.
Okay, please, forgive me, Your Honor, what would be the court's preference?
Share screen?
Do you know how to do that?
And is there sound?
There's sound and visual. The visual is obviously more important than the sound, but both, yes, both of them.
And Your Honor, I would like to, one, see which video it is before it is screen shared with the court.
Your Honor, if I may,
Well, don't you have the videos?
I just want to know which one he's going to be showing, Your Honor.
I'd like to play with Officer Kakis, excuse me. First scout car, just briefly, and then also and next the body cam. But for the record, it's been so stipulated before the exam began.
Oh, I don't have a problem with
Okay,
it. I'm
you
just
just-
suggesting that if you
Oh, sure.
unplug this and connect to the TV, that shuts down the live feed.
Oh, yes,
So
ma'am.
by
I
your
was
share
just
screen-
responding to
Oh.
Sister
Well, and I'm
Council.
not objecting to playing it, I just wanna know which one.
Okay, forgive me again. Both of Officer Tech is just videos.
Okay, and so.
What would be the preference? Do you have share screen on your?
If you could zoom into the gallery, I would have to admit you in, and then
Okay.
I have already enabled the share screen.
Thank you.
And how long are the videos that you plan on sharing?
The first one is roughly 50 seconds, the second one's roughly a minute.
Were you able to get in touch with Ms. Goldberg?
All I can do is send an email.
Because, she was saying it was hardship for her client,
The jail is email.
Which one, or both of them?
Both of them.
Your Honor, may we connect to the Wi-Fi?
Yeah, yes, is that something I need to approve?
No, it should be on
If you
there.
have a proxy server, you need to turn it off.
Hi, Deputy, who do you have there, sir? Oh, Mr. Randall.
Mr. Randall.
This is Jalen Randall.
Ms. Coleman Morrison? Is she back?
Ms. Coleman?
Yes, I've been back for a while, thank you.
That's okay. Calling case number 215909, the people of the state of Michigan versus Jalen Jamal Randall. The defendant is charged with count 1, home invasion, first degree. This matter is scheduled for a probable cause conference.
Thank you. Appearances, please.
We need Mr. Bloomers.
Officer, can I trouble you if Mr. Bloomers is in the hallway?
Yes.
For the record, Delisha Colbert Morrison, P56278, on behalf of Mr. Jalen Randall. Mr. Randall, you can put your name. Good morning. You're on.
Randall.
I know. Say your first name again, sir.
Jalen Randall.
Thank you. Ms. Coleman, you okay over there?
Actually, just the summer cold, because I went in yesterday and checked everything out, got tested, and it is just a summer cold, but it.
Mr. Bloomers, did you want to put your appearance on? This is People versus Randall.
People.
Okay. What is your pleasure, Ms. Coleman?
Got the recommendation, pretrial services recommendation, and just for a point of clarity, the score total on the risk assessment says +1, but in the officer's write-up, it says it's risk level 2, but I see level 1 where the score total is 1. And that being said, the recommendation does state that a reduction is appropriate. I stated the other part in essence because I'm asking for the court to make that reduction, and I accept that I misstated that there was no PPO. There was no PPO served on my client. That the parties had interaction well since January, and my client had never been served with the PPO. But that information being provided, I didn't want the court to think I would ever mislead the court. I was only given the information that my client wasn't aware of the PPO. When I looked online, I did not see the PPO information, and I've looked several times. But we are requesting the court to reduce the bond from a remand, where Mr. Randall only has a misdemeanor conviction in Arizona, which was actually for possession of marijuana at that time. But we're asking for a 10% cash surety bond with tether.
Mr. Bloomers?
Your Honor, I've had a chance to review the DFC report. I don't
ultimately know why the defendant was remanded to begin with. I would argue, you know what, I would be willing to stipulate to the terms of the recommendation of the DSU, which is 15,000, 10%.
All right, which is different than what you were requesting. It did suggest 15,000 with a 10% provision with no contact and GPS tether, with the representation made by counsel to, that he's, you know, has no objection to such an amendment. I will make that amendment to the bond. It is important that your client understand, however, that he will be precluded from any contact with the complaining witness and or her residence, and that GPS tether will be attached before his release. And if he fails to comply in any way, then he's going to be picked up. And that's really important because a lot of times it's tricky. I don't know what happens at the arraignment. We have a bond form. But I don't think the message actually gets through. No contact means no contact. Even if the complaining witness comes to you, you still don't have permission to have contact, and any engagement would be considered a violation. And that would include indirect contact as well. Any form of social media outreach, texting, chat, or even using someone to act on your behalf would cause you to be picked up. So again, I don't know that those things are explained at the arraignment, but it's, I'm taking the opportunity to explain it now. Again, the bond will be reduced in line with what the recommendation is from the pretrial service, the DSU report. It's going to be reduced to $15,000 cash or surety with a 10% provision, plus GPS tether and no contact. We need to set an exam date, correct?
That is correct. Also, Your Honor, just for the record, my client's phone was taken and it has exculpatory evidence in it. I don't believe there was, in my discovery, there was no search warrant to get into that phone, but I need to have accessibility to it for exam purposes and going forward. So just putting that on the record that I need his phone preserved in the capacity that it was taken from him in the hospital. But we are asking for the soonest date possible. I don't know if his family will be able to make 15,000, 10%. They did say they'd be able to make 10,000. That's why I requested it. So we are asking for the soonest date possible.
Can you pick a date, first week in September, or August rather, first week in August?
Do the court do them on Fridays?
Yes.
August 6th would be fine for us, Your Honor.
August 6th at 10 a.m. is going to be the exam date, and we'll see you then. Please make sure that you have contact with Mr. Bloomers regarding the cell phone issue you addressed.
Thank you, Your Honor.
Thank you, Judge.
Thank you for the reduction.
Thank you.
Thank you.
All right, we're back on the record in the matter of People versus Larkin, 1058465. Appearances quickly, please.
Bryn Bailey on behalf of People.
Ed Martell, PA 5051, on behalf of Mr. Larkin. Tony Larkin.
Cannon, P 82992, human assistance, and Martell, we have Mr. 21.
Thank you. Okay, where are we with this issue of the video?
Thank you, Your Honor, for the recess and for your patience. Madam Prosecutor is going to assist with sharing her screen.
Thank you.
Thank you. Now, Your Honor, whenever the court is ready.
Oh, the court, yeah. I'm sorry, I have different
Okay,
views. I'm
my
looking at
apologies.
my view that's best for
My
me,
apologies.
sorry.
Now, okay. Can we run into the beginning, please, just briefly, and at that same speed? That's fine, thank you. Now, officer, you testified earlier that there were, I believe, 3 cars on the road, is that correct?
That's what I recall, yes.
Your
Okay,
Honor, I'm gonna object for improper impeachment.
Madam Prosecutor, you're gonna have an opportunity to cross. Please proceed.
Your Honor, if I might, we played this video in the efforts to refresh a recollection.
I understand. Your objection is overruled. Please continue, counsel.
thank you. Having had an opportunity to review that video, how many cars did you see in proximity to Mr. Larkin's video, or vehicle, please?
From the dash cam footage, it was observed that one vehicle was going westbound and one vehicle was going eastbound sides.
Okay, so obviously, you would not be able to gauge his speed from the vehicle traveling the opposite way, correct?
No.
Okay, and in review of the video, you would agree that the other vehicle, I believe a Blue Explorer, was a substantial distance behind Mr. Larkin's vehicle, would you agree?
To a certain extent.
Okay, at least 5-10 seconds, would you agree?
About 5 seconds. Yeah.
Okay, so did you have a LiDAR gun on you at that time, a speed gun?
I did not.
Okay. Did you have, obviously you were stationary and we're not pacing this gentleman's vehicle, correct?
Correct.
Did you have any other method of calculating or gauging Mr. Larkin's vehicle that day? The data scientific method?
No.
So your observation was the sole basis of your decision to pull this man over, correct?
And the tinted windshield, which is also illegal.
Okay, let's get into that.
Sure.
But before we do, let's get into that. When you pulled Mr. Larkin over, and you lost him for a distance, correct? In review of the video, you lost him for at least a split period of time, correct?
No, I seen him the whole time.
Okay. When you pulled up to him and jumped out of the vehicle, did you alert or notify him of why you were pulling him over?
Yes.
And what was that you told him? Did you say tinted windows and a high rate of speed?
I don't recall what I said, but I just.
Okay, well, would the video refresh your memory?
Yeah.
Okay, and again, this video has not been altered in any way, correct?
Correct.
Okay, Your Honor, may I play the other video, body cam video, please?
Yes.
Thank you.
Oh, we need to call this Nance's case.
And then is Mr. Washington on? No, because it's another jail.
We're gonna break for just a moment. I need to get, call Ms. Nance's standing in for Mr. Chambers on a matter. Is her client, which one is? You know what, I think we lost.
Mr. Vance, Judge.
Hold on, let me just see where he is. I'm not sure which one he is, so I'm gonna bring them both in.
There he is,
Okay,
Judge.
recalling People versus Vance, which is case number 21059104002, I believe is Mr. Vance. Appearance, please. Prosecution?
Does I have the defendant's name, please?
Ms. Morella Smith, state your name, please.
I'm sorry, Your Honor. I'm sorry, the defendant's first name is Terrell, Terrell. Last name Vance. Prosecution?
Morella Smith, P83353 for the people, Your Honor.
And good morning, Judge. May it please the court, Janeki Nance, P68686, standing in for the attorney of record, Arnie Chambers, with Mr. Vance's permission. Is that correct, Mr. Vance?
Yes, Your Honor.
And Mr. Vance, would you please state your name for the record?
Terrell Vance.
And Mr. Vance, do you consent to having this hearing conducted via Zoom today, as opposed to being physically present in the court only for this hearing?
Yes, Your Honor. Yes.
Thank you.
What's your pleasure, Ms. Vance?
Judge, after reviewing everything at this time, on behalf of Mr. Vance, we are demanding his preliminary examination.
August 19th at 1:30 is going to be the examination.
You want to matter?
No, you want to waive it?
No, I do not want to waive it, but from my understanding, Your Honor, I have a right to have a preliminary exam 14 days after my probable cause. So why is it so long?
Okay, Mr., the dates that we were given, all were after that time frame. Unless you have new information, Ms. Vance?
No, Judge, I don't have new information. And Mr. Vance, I thought, if I did not share this with you, I thought I did share this with you, that Mr. Chambers' calendar, that's what we could fit in with the calendar, make Mr. Simon's schedule as well as Mr. Chambers' schedule work. Do you remember us having that conversation?
Yes, Ms. Nance, but that's not gonna work for me. That's too long. I would like my preliminary exam 14 days after my probable cause, which is my right. If I'm wrong, somebody please tell me that I'm wrong. If I need another.
If you want to have the exam on the 21st, let's have it on the 21st. There's got to be an attorney here to represent you. I'm here for whatever you want to do. What would you like to do?
If I need another attorney, that's fine with me, and I'm also asking the courts for a bill of particular on all of my charges.
Okay, so we're gonna pass on this. Sorry.
Okay, thank you.
Back to this exam in progress. Thank you. We're back on the record in the matter of People versus Larkin, and this is 2-1-0-5-8-4-6-5. Appearances again.
Jordan Bailey on behalf of the people.
Ed Martell, 85051, on behalf of Mr. Larkin.
Mr. Larkin, please state your name and counsel.
Attorney Jamonte Cannon, 82992, here to assist Ed Martell on behalf of Mr. Tony.
Thank you. Mr. Martell?
Yes, Your Honor, everyone inclined to court. Sister Counsel is going to play the body camera from Officer Kekis on that day. Thank you. Is the audio on?
Audio, it's always a technological issues with audio unless they step into the hallway. Madam Prosecutor, if he needs the audio, I don't know if he needs the audio.
I do when he steps out of the car, because he, this is where he
Madam
speaks
Prosecutor,
to
do you want to go in the hallway and go into a conference room?
I mean, if it completes the court, I would do the same, so she wouldn't feel.
Well, if someone just needs to put the device in the hallway.
Officer, please.
Well, no, he can't.
Sorry.
I'm gonna leave it to the two of you to figure out.
I don't feel comfortable with myself exiting the courtroom during an exam.
Wait, I'm sorry. So here's the thing, the audio, we're gonna pause. I want there to be a conversation that occurs.
Sure.
It's not something I'm trying to have people out of the courtroom for.
Counsel, please don't find the device out of the court, just let the court. Thank you, sir. Thank you, brother.
Yeah. Okay.
Just make sure you push the audio, audio. Is our 11 o'clock? Is that a custodian or not?
I think everything else is custodial. Is anyone here on Brockman? Or Johnson?
Brockman is in custody?
No, everyone else is out of custody, Judge.
I believe that's one part of it as well.
Okay, let me know when you want me to play.
Please do. With audio, please. Mr. Bloomers, we don't have audio here.
It kicks in.
scene that she was injured.
Hey, give me another car over here to Plymouth and Auburn.
Sorry, do you have audio now?
Yes, sir.
Okay, I'm gonna go back to the beginning for you and then.
No,
Oh,
the
okay.
audio.
Okay.
Yeah, the beginning, if you want to go back to the beginning, it's fine. It's rather quick.
Okay. If there's no audio at the beginning, we don't need to go back to the beginning.
This is good right here. If the court sole planning jumps out.
Well, this we've already seen.
Windows. We're on the window forward. Back side two, please. Yeah, back window two. Roll down. Roll on back window.
Progress of 25 vehicles 0001 single gas station. Some policies occurred for black.
Come on, gonna stop, man. Your speed. And then the vehicle showing have no insurance from the Secretary of State. Is your vehicle?
Yes, sir. Play with insurance.
Sorry?
He'll play with insurance. He just got to play with it.
Okay, do you have insurance? Okay, do you have a valid driver's license? Huh? You're operating the vehicle, sir. So do you have a valid driver's license? Okay, doing fair. Put the vehicle parked.
That's fine. Thank you.
All right, come on up. Face away from me. You got anything on you that's gonna put me stabbing?
Bloomers? Mr. Bloomers?
Thank you.
Yes, Judge.
We're all set, thank you.
Okay.
Your Honor, if I may?
Yes.
So officer, did that refresh your memory?
It did.
Okay, and may I repeat my question? Did you inform my client? Yes, sorry. What infractions, what was the basis of the stop that you informed my client, please?
I informed him at the stop, in regards to the speed and then the insurance, which
Okay, now just to walk back through this, based on the speed, you were again in a stationary place, correct?
Correct.
No unsafe weather conditions, correct?
Correct.
No snow, correct? No ice, correct?
Correct.
No rain, correct? No pedestrian or school crossing zones, correct?
Correct.
Okay, was my client driving erratically as far as swerving? Not alleged speeding, but swerving. But from the video, we agree that he was not doing that, correct? Okay, moving on.
I didn't hear an audible response.
Yeah, I couldn't tell.
Thank you. Okay, so as to the purported violation of insurance on the vehicle, at some point in time after, you did inform him that the vehicle did not have, as the video showed, did not have insurance, correct?
Correct.
Okay, and then shortly thereafter, we can agree that issue was quelled or resolved when you were presented with a valid insurance, correct?
Correct.
Okay, so we would agree that the vehicle did have valid insurance.
It did.
Correct? And there was no unsafe driving conditions, and the basis of the flow of traffic was a visual observation, correct?
Correct.
And there was one other vehicle on the road, a blue Explorer, that was a substantial ways behind his vehicle, correct?
That we can observe in the video.
Correct. Okay, thank you. Your Honor?
Yes.
I have no further questions at this time.
Any redirect?
Yes, Your Honor. Officer, how familiar are you with how your body worn and dash camera operates?
To an extent.
to an extent. So when does your dash cam or body worn camera, when does it initiate, start recording?
It starts recording, once you initiate the lights, the camera kicks on and starts recording, but it does rewind and go back like 15 seconds. I'm not too sure exactly how long it goes back, but it does go back, and then it starts recording with no audio, and then as soon as the lights were initiated, that's when the audio kicks in.
So would the videos that you observed be an accurate representation of everything that you saw in the 2 to 3 minutes prior to turning on your lights?
No, because the way the vehicle was positioned was facing northbound. We could look far enough east and west to observe vehicles coming towards us. And that's not captured on the video.
And during this time, could you observe the vehicle that the defendant was in prior to it coming into the view of your dash camera?
Yes.
Could you provide an estimate of how fast that vehicle was going?
Objection, Your Honor, cause for speculation.
Your Honor, speed is one of the things that anyone can speculate as to. You don't need to be an expert or have scientific data for speed.
Objection overruled.
Roughly around 40, 45 miles an hour.
And do you recall what the speed limit is in the area within which you observed the defendant?
35.
Did the defendant have a driver's license?
He did not.
And is not having the driver's license a detainable offense?
Yes.
I have no further questions.
Is there any follow-up?
Your Honor, may I briefly redirect?
Yes.
Okay. Thank you, Your Honor. So again, Officer Cactus, excuse me. You testified that you couldn't tell with specificity previously how fast my client was going, is that correct?
To exact speed,
Okay.
no.
Could you tell how fast the other vehicles which are traveling in the same direction were going?
Objection, Your Honor, outside of the redirect.
Your Honor, she did bring up the issue of speeding. He said that my client was traveling 40 to 45 miles per hour. In order to gauge that, Your Honor, he would have to know how fast the other cars were traveling in order to say he's traveling outside the flow of traffic.
Objection overruled. Please proceed.
Please answer the question, sir. Could you tell with specificity how fast the other vehicles were traveling?
A proper speed, I would say.
A proper speed, but you couldn't say for sure if they were going 25 miles an hour, could you? Could you tell they were going 30 miles an hour?
Objection, Your Honor.
Please answer the question, my apologies.
I mean, in regards
Your Honor, first, I did object. First of all, compound question, asking multiple questions in a row without allowing the witness to answer. Secondly, Your Honor, he's already stated that he doesn't know with specificity. So I would object to these not only being compound questions, but also asked and answered.
I'll refer to you.
Thank you.
This one. So, again, we've testified that you couldn't tell with specificity how fast my client was driving, correct?
Correct.
Okay. Or how fast the other vehicles were traveling either, correct?
To a specific speed.
Okay, okay. So it's fair to say that you really don't know how fast either one was driving? Correct?
Correct.
Okay. No further questions.
I'm sorry, I didn't get that.
Correct.
Anything further?
No, Your Honor, I ask that the witness be excused.
Thank you, Officer.
All set?
Yes, thank you. Any further witnesses?
No further witnesses for the people, Your Honor.
It's not for defense, Your Honor.
Okay, is there a motion?
Yes, Your Honor. At this time, the people would move this honorable court to bind over on all counts, Your Honor. We heard, for starters, that there was a stipulation between the people and defense counsel as to a 2015 carjacking conviction, Your Honor, which the people do have a certified record of and would be willing to publish to the court should the court require it. This conviction prevents the defendant from being able to have possession of guns and or ammo, Your Honor. The defendant has not exceeded the length of time within which to regain his rights to possess a weapon, and no showing has been made that the defendant has in fact regained those rights. Therefore, Your Honor, the defendant is for the statute classified as a felon. After officers observed several civil infractions and a traffic stop was engaged, we heard Officer Kakish indicate that the defendant was the driver of the vehicle. He did not possess a driver's license. He was going at least 10 miles above the speed limit as to an estimation of the officer. He did not have a CPL, Your Honor, and he was unable to be driving at that time for not having a driver's license on him. The officer asked the defendant to step out of the vehicle, and pursuant to standard police procedure, Officer Kakish asked if there was anything that might hurt him. In response to this, the defendant indicated that he had a gun, and simultaneously the officer felt and thusly located a handgun in the defendant's pocket, Your Honor. I believe he said right pocket, but I believe he did say the right pocket. Your Honor, at this time, the defendant did not provide a concealed pistol license, which is required to carry a pistol upon one's person, not visible to any other people, Your Honor. Therefore, by having a gun in his pocket, not only as a convicted felon, Your Honor, without having regained his rights to carry a weapon, but also the lack of a concealed pistol license indicates that the defendant did in fact carry a concealed weapon and was a felon in possession of a handgun. Additionally, Your Honor, this handgun not only was loaded, there was a full magazine and with one round, I'm sorry, I won't say a full magazine. The magazine did have ammunition in it, live ammunition, and there was one round in the chamber, Your Honor. The defendant, just like the weapon, is not allowed to possess ammunition, being a convicted felon, Your Honor. And by having a weapon in his possession at the time he committed felon in possession of both firearm and ammunition, people have met its burden as to the proofs for all counts, Your Honor, and as such, I ask that this honorable court find over. Mr. Martel.
Thank you, Your Honor. Ryan?
Oh, yeah, yes, but I said Mr. Martel, yes,
Thank you.
thank you.
First and foremost, I would like to commend Sister Counsel. She did a fabulous job, and I would like to thank this honorable court. But the facts are the facts, Your Honor. What we have here is an egregious Fourth Amendment violation. That is the whole basis, the only issue for this court to consider today. For all intents and purposes, pursuant to the Fourth Amendment, that stop was a seizure. And the basis of it, according to the testimony of the officer, was that my client was traveling outside of the speed, a high rated speed based on the flow of traffic. A flow of traffic, which he testified he had no knowledge or couldn't tell with specificity how fast was traveling. He didn't know how fast my client was traveling. He didn't know how fast the other vehicle was traveling. And that speaks to credibility, because initially he said there was a multitude of vehicles, at least 3. And then upon refreshment of his memory from the video, clearly the court could see there was only one Blue Explorer. One Blue Explorer, there was a substantial distance behind my client. How could he possibly gauge my client's speed or even flow of traffic from a vehicle that was 5 seconds behind my client? How? It's illogical. It's impossible. First of all, second of all, he was a drug ops officer. A drug ops officer that he testified specialized in guns and drugs. Probably even, well, guns and drugs is what the testimony was. Okay? Testified that a number of his traffic violations led to these type of arrests. Okay? Second, he testified about this purported window tint. okay, which he never notified my client of, which the video reflected. He walked up to the window and he said, "You've been pulled over for traveling at a high rate of speed, 1, and 2, for a violation of no insurance. A violation which was immediately quelled or cured by one of the occupants of the vehicle." Your Honor, the moral of the story is this. The officer had no special training or experience in speed observation. The weather was not unsafe on that day. He testified that there was no school zone, no pedestrians, no ice, no water, no erratic driving. Okay? The citation that was issued is violation of basic speed law, drove unsafe manner. A citation is generally issued for when an individual drives unsafely in extreme weather conditions. This is an improper ticket. This is an improper ticket. This is an invalid stop. It's clearly pretextual. It's clearly nothing more than a fishing expedition, Your Honor. And for this reason, and this reason alone, this court must not justify the means by its ends. And I respectfully, for these reasons, ask you to dismiss this case.
I had an opportunity to hear the testimony from the officer that was presented by the prosecution. This is a probable cause hearing. The burden on the prosecution is to establish by a probable cause standard Mr. Larkin that crimes were committed in the city of Detroit, county of Wayne, and he probably committed those crimes. With the testimony of Officer Packish, the officer articulated his observations on the date in question and the reason why he had stopped the vehicle that the defendant was occupied as the driver. And he indicated, whether you like it or not, the testimony revealed that he indicated that in his observation, what caught his attention is that the vehicle was speeding and it passed exceeding the speed limit and that the vehicle had tinted windows. That was what caught his attention. He eventually effectuated a traffic stop for which he determined the driver, the defendant, whom he identified here in court today, did not have a driver's license or an identification card. And in asking the defendant questions as he was detaining him as to whether or not, which I think there were questions that any officer would be remiss if they didn't ask, if there was any thing on his person. The defendant indicated that he had a firearm and he felt a firearm in his pocket or his pant pocket. And that firearm was recovered, was seized, was placed on evidence. That evidence tag number was placed on the record. That firearm was loaded and there was a clip for which the officer testified to. I've seen the body cam. The court's had an opportunity to see that. You gotta take that into consideration as well. This is a probable cause hearing. This isn't a trial date. And there has to be an appreciation for that. It's a lower standard. Many attorneys don't like that it's a lower standard, but this is how the system is set up. And so until that changes, probable cause is a term of art that we use in the legal field, and probably worth having a discussion with your attorney about, Mr. Larkin. But the prosecution has met the burden here to establish by probable cause standard, coupled with the stipulations that have been placed on the record at the onset of this examination. They've met the burden to have this matter bound over as charged for further proceedings with an AOI date of July 21st at 9 a.m. There was another issue you said you wanted to address.
Yes, thank you, Your Honor. So I've had an opportunity to speak with sister counsel, and based on our discussions, we respectfully request the court that we maintain the writ on Mr. Larkin so that we may work towards discussions and a reasonable resolution. In addition, Mr. Larkin did see the doctor up there at the Jackson facility where they indicated he was experiencing or exhibiting some medical ailments that I would like for his family to be close to him during this time, and I would respectfully request the same of the court to maintain the writ.
Well, now that he's got an AOI date of July 21st, I don't think he'll be moving too far. I think the normal course of action is for the defendant to remain in place at Wayne County Jail and to have the arraignment on the 21st.
Your Honor, my respectfully request of the court that we, and I know this may be non-traditional, increase or modify the bond to a cash bond from the personal bond, even a $5,000, 10%.
Sure. Can you pass him a bond form so that he can prepare that and add his signature to it?
Thank you, Your Honor.
You're welcome. All right, we are all set here.
Mr. Martin, I'll be ready to get to you. Thank you.
Trying to find the form. We've got a couple of matters that we need to, well, you know what?
I don't know, I know
Ms.
what's messed
Nance,
up.
did you need another breakout room?
Yes, please, Judge, if you can place me in the breakout room with Mr. Vance, please.
And,
I'll grab everyone but the Browns.
Unfortunately, no, we just need to. Um, Okay, can I have the, Miss Bailey?
Ms. Brady?
Miss Bailey?
Is Ms. Bailey in the hallway?
Yeah, we have Johnson, we can put that on the record, otherwise we're going to have to, I'm sorry, whoever's handling the Brockton matter, is that, who's handling that?
I have Johnson, it's gonna be a quick one.
Okay, but I don't see anybody, so I don't know. Who's the defense counsel? I'm talking about the one Mr. Bloom is talking about. On Brockton, we're going to have to either adjourn this or do this at, Morales Smith, are you present?
Yes, Your Honor, I'm here.
Recalling people versus Terrell Vance, 210-591-0402. This case has already been formally called. Appearances again.
Lloyd Morales Smith, P353 for the people, Your Honor.
And Jeanette Cunane standing in for the attorney of record, Arnie Chambers, appearing on behalf of Mr. Vance, who's appearing from the Wayne County Jail. Mr. Vance, state your name for the record.
Terrell Vance.
Thank you. Do you want the exam next week?
Yes, Judge, it's my understanding from Mr. Vance, he wants a date, an exam date within 21 days of being arraigned on the warrant. I've had opportunity to speak with Mr. Chambers regarding a date. The only day that he is available that would be within that time frame would be Tuesday, Judge. I don't know if Mr. Simon, who was the attorney for defendant number one, I believe in this case, is available, but that is the only date that Mr. Chambers would be available.
Well, we will have to bifurcate them. So we'll set it for, now keep in mind, please tell Mr. Chambers to be patient on that date, because it is bursting at the seams on that date, but we're gonna set it for.
Sorry, Judge, I didn't hear you.
We're gonna, well, do we have an afternoon that day?
No, that's a Devon case.
But
Wait, I'm sorry. Run into the afternoon.
Okay,
Set for
then we'll
1:30.
set this for 1:30. They'll have to, if we have to go beyond, we'll just have to bifurcate the phone number. You know what I'm saying? So
No, I just
we'll
wanted to
start
know
it.
who was scheduled there.
Yeah. 1:30 on July 20th.
Your Honor, I have a 1 o'clock appointment.
Well, I'm gonna need for the two parties to figure it out, zoom back in an hour's time, and then we'll put it on the record. Everybody perhaps can, Chambers, you can get everybody on the same page. I'm here to do it tomorrow if you'd like, Mr. Vance, but I just need everybody to be a party to it. So it sounds like there needs to be.
That's fine, Your Honor.
I understand, Mr. Vance. It sounds like there's some communication that needs to be had, and I have an emergency. So I'll be back on the record at 12:30, okay? Thank you so much.
Thank you, Judge. Ms. Morales, do you want to give me a call? Let me put my telephone number in the chat, and I will see what we can get worked out with this.
Absolutely.
Mr. Washington?
Yes.
Yeah, just go
Yes.
back in at 12. Whichever video room, Mr. Clemens, can you get a deputy for me, please?
You guys be back at 12:30.
Good morning.
Yes.
Yeah, we're gonna have to recall Mr. Clemens' case at 12:30.
Okay. Now, I'm supposed to be down at 36 on a preliminary examination. Well, I'm a little late for that. So is it possible I can be there in person, because I'm going to be down in 36th district anyway?
Okay, that's fine.
Okay, then. Thank you.
All right.
Bye. Bye.
So Tammy, 12:30?
Yes, please.
Thank you.
All right.
Oh, waiting on the bond paper.
Okay, just.
Oh, no, take your time,
You have
take
to
your time.
chill, don't be rushing me now.
Take your
You
time.
know what is your, because someone else entered an appearance on this case that's not you.
Really?
So I'm just trying to figure out who's got the right, and I've got to find the file.
I sent you a copy the other day. There was actually two different people that entered appearances on this.
I'm just trying to make sure I get the right one, because on July 1st, a cold.
Yeah. I don't know why, because the judge already released him in the last PCC. I don't know why he did that. Yeah, put your arm.
Well, he probably went through the through the court's email.
Maybe.
and It takes time.
That was a CYA.
So were you retained on it?
Yes, I was.
Mr. Nasser, I get all kinds of P numbers.
No, I was the
from
last
Val's
one
office.
retained.
Okay, so
Yes,
what's your P number?
85051.
Okay, so
Thank
give me
you.
just a minute and I will give you a copy of it.
Thank you so much.
I don't need a Bible.
I'll speak for
I
us.
just have one question.
Yeah.
Wells is here. If I'm not mistaken, it's
12:30. Let us have to call back at 12:30.
You
Zoom
want
back
to
in,
come on Zoom?
Zoom back at 12:30.
Okay, so tell Will to leave and Zoom on.
Yeah, but he was having trouble with his phone, so if he wants to just hang around out there and come in at 12:30, he can do that.
Okay.
Miss Bailey, do you want a copy of this bond increase form?
Yeah, I'll give it to him. Mr. Martin, can you come get your stuff? We got to shut the courtroom
He can
down.
have that copy because the other one, the bill needs the yellow copy.
Mr. Martin?
I think it's Martell. I'll do this paperwork and we'll take care of it when we come back from lunch.
Oh, I was just waiting on the Darius credit dismissal.
For who? Okay, I already did that. Sometimes you guys want the copies and sometimes you don't, so.
No worries, thank you, ma'am.
Most of the time you guys don't want them, but I can see this one's kind of special.
Yeah.
Here you go.
It's only on these that we want them.
Yep, there you go.
Thank you, ma'am.
Yes, thank you, Ms. Jones.
Yeah, no problem. You have a good day.
Oh, that was scheduled, but it's not going. Have a good day.
You said the notches here on right, that was the one that got rescheduled. or something?
Yeah, that was adjourned.
Adjourned.
Let me look it up real quick.
Yeah.
They adjourned it yesterday.
I'm gonna do this, man, we'll get it out. Do this, make it
No,
well.
that's not it. There's a lot of stuff going
All right.
September
I'll see you
7th.
on Friday.
At 1:30.
September 7th, you won't see me out.
9/7?
Yep, at 1:30.
At 1:30.
Okay.
Vacation?
Huh?
Vacation or you working?
Work.
Oh.
The recorders like needed.
I told you this, Jill.
That's on me? You gonna like put it all over me?
The lunch?
Yeah, you said lunch only.
You know what? I don't want to do that. I'm scared.
You scared? No, I know you ain't scared.
We got it.
Where we having lunch at?
Hey.
That sounds good. Where's that at?
Right now.
Because I don't have my AAA card. She said.
Where's that at?
Oh, grandma's right there.
You say grandma's right there. Where is it?
Right here by the-
Oh, it's all this.
Yeah, I have one, but I'm at work, and it's in the car. Huh? All right. What's wrong with Ida? Huh? Put her on the phone. Isla,
Oh.
Isla, boo boo, what's she doing? All right. What's going on? Okay.
Early lunch.
Y'all front door. Yeah, go ahead and call mommy.
We're down for lunch.
Do that, okay?
Have 11:30.
We gotta come back at 12:30.
Oh, do you? All right, okay, all right.
Oh, and she didn't even look out for us and turn that screen off.
Y'all done?
Nah, man, we waiting on
I'm trying to think.
Hello.
Hello?
That's okay. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence, habitual offender, fourth offense notice, and this is Mr. Clifton Lewis Wells. It's scheduled for a preliminary exam.
Okay, appearances, please.
Good afternoon, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good afternoon, Your Honor. Jennifer Colthurst, P52876. I appear on behalf of Mr. Clifton Wells, who's present in court.
Thank you. Mr. Wells, please state your name.
Clifton Lewis Wells.
Thank you. Today is the date and time set for a preliminary examination. Are we proceeding to an exam today?
Your Honor, at this time, the complaining witness, Marlo Talley, is not present at the courthouse. They were not present at 11:30, which was the scheduled time for this exam. Without their present participation, people are unable to go forward.
Defense moves. Yes, Your Honor. Defense moves for dismissal if the government isn't ready to proceed.
Thank you. I'm going to grant that motion to dismiss. Keep in mind, Mr. Wells is dismissed without prejudice. And what that means is that it is possible that the prosecution can reissue on this case. If you have questions regarding what that means or the parameters of that, please make sure you speak with your attorney and she'll explain it to you in greater detail. Do you have on a GPS tether that needs to be removed? I'm going to include the language that GPS tether shall be removed forthwith. You'll have a copy of that to take with you to the tether unit. And you will also alert them from here that it should be removed as well. Ms. Colthurst, do I have permission to sign your name to the order of dismissal as the moving party?
Yes, Your Honor. Thank you.
You're welcome.
Just wait in the hallway and they'll bring that copy out to you. And don't forget to sign off of Zoom when you go back out to your car.
Sign off.
Yeah, right in the hallway.
Thanks again for everything. Everyone have a great afternoon, everyone.
You too.
Thank you.
Judge.
So she's a lot like you, always pleasant.
Oh, Miss Colthurst. She has a pleasant voice.
Yes, she does.
I'm not sure, is that Mr. Yankees? Why, because we did have one more jailer too. But I don't see Mr. Washington.
I see Prosecutor McIntyre. I think Prosecutor Morales Smith is here as well. Miss Nance, do you have your client? I see that they're logged in, but they're still there.
Judge, I think he may need to turn the video on. He was the WCSO.
Yeah, I don't know.
So is that Mr. Clemens that's there then?
Okay, recalling people versus Vance, Carol Vance. This is 21059104002. I just was assuming that they were going to turn that camera back on.
Okay.
And
Your Honor, he's being pulled right now for court. Hold on 1 second.
okay. That's okay. Me too. Can I have appearances in anticipation of him joining us?
Lori Morales Smith, P8353 for the people, Your Honor.
And good afternoon, Judge. May it please the court, Jeanette Nance, P68686, standing in for the attorney of record, Arnie Chambers, on behalf of Mr. Vance.
And he is still not there.
Maybe prosecutor would keep a number, please, Judge. Always stays on.
Can you repeat your P number, Ms. Morales Smith?
83353, Your Honor.
Thank you.
All right, that must be Mr. Clements thing on video. Ms. McIntyre, do you have Mr. Washington's cell number? You can shoot him a text.
I did, and he indicated he should be available in about 15 minutes.
Oh, okay. Okay, let me
Is
see
it a
if I can.
PCC?
Huh?
It's a PCC?
His client is, yes. He's the other person in custody. Let me see if I can call the jail. I saw a deputy come up though, on a different screen.
He said he was getting ready to get Vance.
Oh, okay, so we're just gonna wait then, okay. Gotcha. Can you mute that for just a second? Yeah.
Okay, can you state your name, Mr. Vance?
Terrell Vance, Your Honor.
Thank you. Madam Defense.
Thank you, Judge. So we've had an opportunity, I believe we have a date that would fall within the time frame that Mr. Vance is requesting. Judge, I did understand that the court indicated that it may have to bifurcate this matter. It appears that July 20th would be the date. Is that correct, Ms. Morales?
Yes, Your Honor, and I will just work around my other appointment, either get someone to cover it or just move it.
Okay, so the examination for Mr. Vance, this is not going to be the examination for Mr. Winarski. This is only for Vance. Is going to be July 20th at 1:30. Now, if Mr. Simon at some later time zooms in with prosecutor and says he's okay with that, that's fine. This will not be the first time that co-defendants have been separated. Is it ideal? No, it's not. I understand that. I appreciate that. But I'm not gonna force Mr. Simon to be there if he can physically not be there. So this right now is only solidifying that Vance is having an examination on July 20th, and that's going to start at 1:30 in the afternoon. Sounds like we'll probably need not only to split the two defendants, but this will probably result in, from what I just would guess, this boiling over to another day as well. We will have to cross that bridge when we get there to set that new date so that Mr. Chambers can participate on whatever spillover might be required. If we're able to complete it in that afternoon's period, fantastic. But if not, we will have to, I don't want anybody to be caught off guard. We don't continue with the court proceedings until 7, 8, 9 o'clock at night. If we cannot finish within the time frame allotted, we will have to select a date to hear the balance of the exam. So for now, July 20th at 1:30. At which time, if this matter does travel beyond district court, I certainly hope that Mr. Chambers will speak to his client with regards to the weight that he will have to endure if this matter proceeds past district court. because have they even started? I think it's
Judge,
next week.
No jury trials have started yet.
Yeah, so I hope that, I always say, I hope that the defense attorneys are having conversations with their clients regarding how the pandemic has affected the system. It's unfortunate, but just like any other facet in life, the pandemic has wreaked havoc. So not only is there a backup here with defense attorneys' calendars, the court's calendars, but that backup is tenfold in circuit court because they haven't even picked back up yet, fully. So with that being said, I just put that bug in Mr. Vance's ear. I'm certain he'll have a conversation with Mr. Chambers, and Mr. Chambers can fully explain how the pandemic has affected things. And then he could cross that bridge when he gets there. But for now, we've got an examination date, July 20th at 1:30.
Yes,
Judge, there are a couple of additional things I would like to place on the record on behalf of Mr. Chambers, if the court would allow.
Yes, please.
Thank you. Judge, I have had an opportunity to speak with Ms. Morales-Smith as regarding some additional discovery things. I do want to place those on the record as he has asked me to. And she does have a list of these things. He was seeking the medical records from Dewan McGee, who was shot in the leg and was transported to St. John's Hospital. He was requesting any and all 911 calls. Previously, we did not have an information. We are currently in receipt of an amended information. He was also asking for a PCC form. He was asking for body worn cameras for the following officers: Alexander Gunther, Dion Corbin, Eric McCombs, Yvette Hudson, and Shireen Ibrahim. He was also asking for scout car video for scout number 937 with the video of vehicle number 185007, as well as scout 598 vehicle 205060, and any recordings of live videos. He did advise me that he is in receipt of paper discovery, judge, as well as the DDC interview from Genetech format, and 15 body cameras, as well as scout car videos. With that being said, Madam Prosecutor has advised me that she will attempt to get that information. With that being said, I would like to place on the record to Mr. Vance that because he has demanded his preliminary examination within his time frame, it is my understanding from the prosecutor that she may not have all of that discovery by the time it is time for him to have his preliminary examination date. Mr. Chambers is aware of that. With that also being said, Mr. Chambers wanted me to advise Mr. Vance on the record that it is highly probable that he will not be able to obtain a jail visit to see him before that. He may not be able to go over all the discovery that will be associated with this case. And his policy is not to discuss in detail all of these things on the telephone. So, Judge, I just wanted to make a record on behalf of Mr. Chambers of the information that has been provided, because Mr. Chambers was requesting a date further out in order to give him an opportunity to adequately prepare. But keeping in mind that this is Mr. Vance's case and he is wanting his preliminary examination sooner, we thought it was very necessary to place all of that information on the record.
Thank you, and I would agree. I would just ask that, has that, the request, the additional discovery that's being sought that you just articulated on the record, has that been reduced to writing? And if so, yes, has it been?
Judge, I did provide that information to APA Morales-Smith this morning while we were awaiting court. I do believe that she is in receipt of that request. She can confirm.
Yes, Your Honor. Ms. Nance put it in the chat. I copied and pasted it into a program so I could have it in paper hard copy and be able to again send that request to my OIC so that those additional items could be added, because the defense attorneys are in receipt of everything I currently have.
Perfect. Okay. Well, please make sure if in response to the inquiries about that additional discovery, if you find that there's any information or feedback from your OIC, please do relay that back to Mr. Chambers so they know what to expect. And as it relates to the second item that you indicated, yes, I'm glad you placed that on the record as well. I'm sure Mr. Chambers, if he were here in person, he would have said the same thing. And Mr. Vance is in custody and is very determined to forge ahead, knowing that there is the potential that Mr. Chambers may not have all of the information and or an opportunity to review same with him prior to the exam, but he's still steadfast in wanting that exam. And so we're going to give that exam to him. Again, that date is going to be July 20th at 1:30. And is there further?
A couple of different additional things. I did forget, Mr. Vance did state to the court previously that he was requesting a bill of particulars. So we would, I guess, renew his request. And then, Judge, there is also a pretrial investigation service report that is present that Mr. Vance wanted me to address.
Bill of particulars isn't typically something that is tendered in district court. Perhaps that's a discussion that Mr. Chambers can have with Mr. Vance, but I'm going to leave Madam Prosecutor to either respond to that or provide a bill of particulars. That's going to be a discussion that needs to be had between the prosecution and Mr. Chambers. If she can provide that, great, but that's nothing that we need to actually discuss at this juncture, especially since Mr. Chambers is not here. But that's a third item, well, really it's the second item that I would like for Ms. Morales-Smith to make sure, now it's been placed on the record, that Ms. Morales-Smith, sure she follows up with Mr. Chambers about same.
Understood, Your Honor. So noted.
Okay, thank you so much.
And Judge, finally, Mr. Vance would like me to address the bond.
Okay, please proceed.
Judge, I believe currently Mr. Vance bond is set at $500,000, 10% with a GPS tether and house arrest. Mr. Vance, he is seeking a reduction in bond. We do understand that the charges that are alleged in this particular matter are serious offenses. They are capital offenses. And I do understand that when looking at a bond reduction, there are two things that the court must consider. You know, the danger, specifically the danger to society, as well as what's going on with his history of coming to court. Judge, in this pretrial service investigation, pretrial report, it indicated that there appears to be a capious history. It looks like the days associated with that were time periods for capious when he was actually incarcerated. If the court would look at the rest of the report that is entered, he does have family ties. And the family ties are involved with his mother, who is present, who, if I remember correctly, has indicated that if his bond was reduced any further, that he would be able to live with his mother. Again, I do understand the nature of these charges, that they are allegations at this particular time. I'm not sure that Mr. Vance has had any charges of this nature in his past. At this time, what we would be asking the court is to consider reducing the bond to $250,000, 10% GPS tether, as well as house arrest.
Madam Prosecutor.
Your Honor, in reviewing the pretrial investigation summary, the defendant does have a criminal history. These are very serious charges. And for the risk assessment, they don't feel that he is a good candidate for a reduction. The people agree with that report 100% and would support that. These are very serious allegations, and in what is looking like a crime spree. So the safety of the public is definitely in question here, and we would respond to stay as is.
Your audio dipped, and Madam Court Reporter needs to hear. Can you repeat at least 3 sentences back?
Oh, I'm sorry, Your Honor. Is that better?
Yes.
Okay. The people would agree with the pretrial services report. They find him to be a high risk because of his criminal history and because of the alleged charges in this matter, which were the result to be a crime spree, the people of the city are in danger, and we would ask the bond to remain the same.
Okay, I've had an opportunity to review the pretrial services report, as well, and I am not comfortable with amending the bond. The court has to analyze whether or not there was an abuse of discretion in setting the bond, from the arraigning magistrate, and, you know, I don't see one. But even if I were to push past that and go through the analysis that one would typically do when addressing bond, whether or not the defendant will reappear, I'm concerned. The second prong of the analysis causes even greater concern. That is the safety of the community at large. The allegations before Mr. Vance are extremely serious and assaultive in nature. And coupled with those two factors, putting him at a high risk level, this court has not heard anything on the record that would warrant any change in the bond at this juncture. Now, after the preliminary examination, if perhaps, you know, there is something that causes the court to change its mind, the motion can be renewed at that time. But at this juncture, there's nothing that's been placed on the record or contained in this pretrial services report, which, by the way, let me reiterate, does not suggest that there be any action taken on the bond. The court is not comfortable with amending the bond at this time. So with that being said, the bond is going to remain the same, $500,000, 10% provision, with GPS tether and no contact. That is an exam date of July 20th at 1:30. We will see you then.
Thank you very much, Judge. You and your staff have a great afternoon.
You too. Thank you for your patience. Mr. Washington.
Thank you, Your Honor. You have a great day.
You too. Thank you, Deb.
Thank you.
Calling parties on Clemens, case number 2159240, the people of the state of Michigan versus D'Angelo Cash Clemens. The defendant is charged with count 1, kidnapping, child enticement, SOR notice, habitual offender, second offense notice. The defendant is also charged in case number 2159328, the people of the state of Michigan versus D'Angelo Cash Clemens. The defendant is charged with count 1, police officer, assaulting, resisting, obstructing, count 2, police officer, assaulting, resisting, obstructing, causing injury, habitual offender, second offense notice. These matters are scheduled for a probable cause conference.
Thank you. Appearances, please.
Good afternoon, Abigail McIntyre appearing on behalf of the people, P71143 on both cases.
Good afternoon, Earl Washington, Neighborhood Defender Services of Detroit, P31383 on behalf of Mr. Clemens on both cases.
Thank you. Mr. Clemens, please state your name, sir.
D'Angelo Cash Clemens.
Thank you. With today being a PCC, what's your pleasure, Mr. Washington?
Judge, we're going to ask for a preliminary examination date, a live exam.
Would you like to select a date?
Oh, okay. Let me look at my schedule.
Your Honor, there is going to have to be a protective order entered for release of kids talk. Just so the court is aware, the complaining witness in the kidnapping is 5.
Okay. That will be forwarded to the court?
Yes.
Looking, any date of the week of the July 26th, except the 27th and the 30th. So I'd be available July 26th, July 28th, or July 29th.
Judge, do we need an afternoon?
I would prefer one, given the nature of the allegations. I don't know that we have one.
No, I don't. We have one.
Is there any non-custodial? And I know I ask this every day, but is there any non-custodial matter we can bump?
I don't think so. Let me look.
Your Honor, I have to step away from the record for a quick second. I have another court on who's trying to get a hold of me. I just need to let them know I'm on the record with you.
Okay.
Jean Guerrero has reckless driving causing serious impairment.
Was that one, was that
They're out.
They're out. Was that an
Yeah.
interpreter one?
I think so.
Then that's, if they're out, that's gonna have to move. I
For
hope
some
that they can
reason,
work.
we removed it from July 9. And we put it on July 26. Officers unavailable, minutes pre-presence way. Yeah, looks like, but that's probably the best we've got.
Yep.
So I'm just have to notify parties. That's a good date. July 26th at 1:30.
Yes, that date is good for the defense.
And we'll see what Ms. McIntyre says.
Okay.
Okay, sorry about that.
That's okay. July 26th at 1:30.
I have a feeling that's a really bad date. I have a 1 o'clock in Lincoln Park.
Ouch. Everything else is, we have custodial matters every other day.
Yeah, I know the feeling. I could do the 27th late in the morning. But after that, I have exams every day, and then I'm on vacation from the 5th to the 16th.
Oh, we can do it. We can, well, we can start it at 11:30.
Yeah, okay.
On what day?
But I think that Mr. Washington said he could you do the 27th?
Let me see.
Because I don't know that we have anything else until we move into mid-August.
I can do the 27th if it's the afternoon.
I can't do the afternoon. I have a 2 o'clock.
Okay.
I could do the 4th of August or the 18th.
That's 2 cases though. How many witnesses?
Did you say August 4th?
Yes.
Yeah, August 4th looks good.
Your Honor, there would be about 3 witnesses for 2 cases, 3 to 4.
Okay.
Yeah, that case we've already got 2. Looks like they're out maybe, but we've already got 2 dates scheduled for it.
Oh,
Engler.
no, let's not interrupt that then. What was the second date you mentioned?
The 18th.
The 18th is clear.
Mr. Gibson, DeMarco. It's a controlled substance. It's a drug charge.
So he's out?
He's out. We can schedule that at 1:30.
Yeah, the 18th at 1:30?
That's fine for the people.
That's good for the defense. Right.
Okay, August 18th at 1:30.
And Mr. Clemens, I'll be over there to see you.
Yes, sir.
Do you have any discovery concerns?
I just received the discovery yesterday.
The written discovery? There's plenty of, I will be in contact with you, Mr. Washington, to discuss the digital.
Yeah, okay, I did receive the paper discovery, so.
All right. Okay, I'm making a notation of same. And is there anything further?
No, nothing further.
Judge, can you order a pretrial services investigation?
Sure. Sure can.
All right, thank you.
You're welcome. And in the event that you want to tee this up for a bond motion upon receipt of that, if you think that it's appropriate, then you can notify prosecution and the court, and we'll tee it up for a bond motion. Otherwise, we'll see you August 18th.
Okay, thank you very much, Your Honor. Have a good day to you and your staff.
You too.
Thank you, Your Honor.
Thank you.
You're welcome. Thank you.
See, that's it.